May I please, Lordship? Lordship, I beg to mention item number 17. Kindly, it may be accommodated on a Monday, Lordship. That's 9.
Okay. On a request made by Sri S. Tapin, Learned Senior Government Advocate, appearing for the appellants, matter is adjourned to be listed on Monday next. Please give the date.
9, Lordship.
9th.
All right.
May I, Lordship? I would like to mention item number 6.
Yes.
On behalf of T. Tapak, leading counsel is out of session and we have taken consent from other party. Item number 6. Yes.
Yes, Madam Pangu, anything?
No, yeah, that's it.
On a request made on, what is the matter about? Yeah. What is it?
In this PL, they have said in the PMGSY, my lord, there is no provision for land compensation, my lord. It is the central scheme. The secondly, they says, my lord, the NOC has not been obtained by the user agency, my lord.
Okay.
These are the two measures.
On a request made on behalf of the petitioner, matter is adjourned to be listed after 1 week,
After 2 weeks.
2 weeks.
Hmm.
Yes,
Lordship, another matter, item number 15.
1-5.
Item number 15.
Yes.
Admission hearing matter. Here,
Not admission hearing.
hearing matters.
Criminal appeal of 2022. Yes, what is your prayer?
Sir, Lordship, we have taken consent from other party.
What is your prayer?
Leading counsel is out of session. On behalf of T. Tapak.
Yes, madam, you are for the respondent.
Yes, your lord.
When do you have? After 2 weeks.
2 weeks, Lordship.
Same order in 20 and 15. On behalf of the appellant, petitioner, no, appellant, criminal appeal. Yes.
May I, your lordship? Your lordship, I beg to mention item number 16, your lordship.
1-6.
That R. Mishra is still not recovery from his illness, your lordship, and he is conducting counsel for this matter, your
Who is
lordship.
the
R.
conducting
Mishra.
counsel?
R. Mishra, your lord, Ravi Mishra.
Oh, this matter was fixed today, as you.
Yes, and he has also instructed me that the client is not cooperating and they have taken back the brief, your lordship. So we are no longer represent the applicant, your lordship.
This matter was taken up on Monday. Chief has come to say he wanted to do the matter. He said,
The other matter also.
there is nothing in this matter.
Yes. Okay.
But it cannot go on like this for indefinite time. Mr. Mishra, either he appears or doesn't appear. If you do not appear, we will appoint an amicus.
He instructed me that he will no longer represent the applicant, yourself. Kindly notice may be issued to the
Can we
applicant.
record this, your submission, and we can appoint an amicus, madam?
Yes, Lordship, they can do, Lordship.
But we give a chance to the appellant to engage another set of counsel. If it does so, it's okay. Otherwise, we appoint an amicus.
Right.
Okay. What is your name, madam?
I'm sorry, your lordship.
You're with Mr. Mishra.
Yes.
His name is not appearing in this.
In cause list, his name is there. your lordship.
First list, his name is not there. In the Wakalatnama, perhaps it is there.
I mean, Wakalat Nama.
Ms. So-and-so Learned Counsel has made a prayer for adjournment on behalf of Sri R. Mishra.
Yes, your lordship.
R.S. Mishra, I think.
Ravi Mishra. Your lordship.
R. Mishra. He comes from Guwahati.
Yes, your lordship.
R.S. Mishra, I think. R.S. Mishra. Hello. Oh, full stop. Sarah, even in the last occasion. decision when the matter was listed. That is Monday date. Adjournment was sought for on the same ground. Full stop. Ms. Swenso has submitted that since the client is not cooperating, the Sri Mishra would no longer appear in this matter. Full stop. Para. No, no appear in the matter, and the brief, in fact, has been taken back. Full stop. Para. Also heard Ms. Al Hage, Leonard, APP Assam, and you are for?
Arunachal.
You are G. Gini, and as well as G. Gini, Leonard, Legal Aid Counsel for the respondent number 2. Para. In the interest of justice, matter is adjourned by 2 weeks
Yes.
to enable the appellant to engage a fresh set of counsel, failing which this court would explore the option of appointing an amicus curiae for the appellant.
Obliged.
Yeah, Your Worship. I may be allowed to mention item number 18.
Yes,
Yes, here I'm representing respondent number 4, private respondent.
yes.
I'm praying for an adjournment, Your Lordship. Yes, connecting counsel, Mr. Asonar, due to personal difficulty, he is not available today. It may be listed after 3 weeks.
Okay, on a request for 25 matter, okay, on a request made on behalf of Sri R. Sonar, Learned Counsel for the private respondent. Matter is adjourned to be listed after 2 weeks,
3 weeks.
3 weeks.
Item number 1.
Please, my lord.
On, yes.
My lord, it's the PL, my lord. In respect of the, my lord, headquarter construction of infrastructure and headquarter CG of the Lower Siang, my lord. Here, the quality, the construction of building and other structures, the substandard quality has been maintained, my lord. My lord, my lord, may I take my lord?
What are the materials to substantiate your allegation? What are the materials to substantiate your allegation?
Yes, my lord.
Allegation.
Yes, my lord.
How do you substantiate?
Yes, ma'am. My lord, the water supply for curing the cement, concrete, etc., my lord, it's not available, my lord. My lord, may I take my lord to the photographs? What they've done is, my lord, they've temporarily constructed a small pond, my lord, for supply of the water, my lord. And the foundation for the structure, my lord, is also not but the standard, my lord. So, my lord, may I take my lord to the picture? Start from page 31, my lord.
First, tell us who are you?
My lord, petitioner 1 and 2 are the practitioner lawyers, my lord, and 3 and 2,
One is a lawyer.
1 and 3.
He is also an advocate.
Yes, my lord. 2, 4, and 5 are self-employed of the area, my lord.
Where do you reside?
Likabari, my lord. That's a particular area. But we have submitted complaint also before Deputy Commissioner as always to the Chief Minister, my lord. Ventilating all these grievances, my lord.
Which photograph are you trying to?
Yes, yes. My lord, may I come to the face. Yes.
Page
Start from 31, my lord.
31.
Is the structure, my lord, building structure we have initiated.
Yes.
And my lord, regarding water, my lord, may come to the phase 34, my lord.
34,
Yes, my lord.
yes.
These are the source of the water, my lord.
Hmm.
And my lord, next page is also source, my lord. And my lord, page 36, my lord,
Yes,
is the small natural pond, Marxist, my lord, temporary reservoir, my lord. And my lord, below is a temporary reservoir, my lord.
Hmm.
And syntax
Hmm.
for supplying the water, my lord, at
Yes.
the working place, my lord. This is not sufficient, my lord, for construction of concrete, my lord.
but this is a large, big, sufficiently big artificial kind of a reservoir made by use of polythene, and they have reserved the water. What is your expertise? How do you know how much water will be required?
My lord, as may I take my lord to the next annexure, my lord,
Yes.
starting from page 37, my
37,
lord.
yes.
Is the, my lord, list of Indian standard, my lord, related to the building construction, management, and quality control, my lord.
Hmm.
My lord, may come to the next page 38, my lord.
38,
Yes, my lord. 5.4, my lord,
yes.
water, regarding water, my lord.
Hmm.
Water used for mixing and curing shall be clean and free from injurious amounts of oil, acid, alkalic, salt,
Mhm.
sugar, organic materials, or other substance
Mhm.
that may deleterious to the concrete or steel.
Hmm.
The potable water is generally considered satisfactory for mixing concrete. As a guide, the following concrete represent the maximum permissible sway room. These are the, my lord, standard.
Okay.
And next, my lord, may come to the required moist, my lord, porta concrete, my lord. 13.51, my lord.
Hmm.
Next page, my lord, 39.
Yes.
13.5.1, my lord.
So how do you say, Mr. Tar, that this water which has been stored would be insufficient or lacks the quality for the concrete mixing?
Because, my lord, they brought that water from the distance, my lord. And that will,
If water is not available there, it has to be supplied from some distance.
PHE is the, my lord, water reservoir has to be constructed, my lord.
No, this water which the temporary reservoir has been constructed,
Is that water is brought from the other source, my lord. And that will not sufficient, my lord. Because,
so how do you know it is sufficient or not? What expertise?
my
What
lord,
materials have you stated?
my lord, what
So
happened?
this pond, the photograph of which is only to bring home up surprise satisfaction, but this pond at page 36, artificial pond, is sufficiently big. How much water will you need? See page 36.
Yes, my lord.
One is a natural one. Even if you assume that natural water, that water, pond water may not be clear. This is artificially made. It has been filled up by bringing water from outside.
Yes, my lord.
Will this be enough to invoke the extraordinary jurisdiction that too in a PIL?
And moreover, my lord, regarding the putting, my lord, base, they have not maintained as per the standard, my lord. Therefore, our prayer,
What is the material?
yes,
What material, your submission is based on what material?
my lord, we have filed RTI also, my lord. They-
Let us see where.
Yes, my lord, RTI. We have filed two RTI, my lord, regarding starting from page 40, my lord.
40, yes, you have seen. Which material are you depending upon?
And my lord,
This is the question. What is the response?
no response, my lord. And my lord,
If it is no response, you can file an appeal.
that's there, my lord.
It's a different avenue.
My lord, that's there, my lord. Also, my lord, come to the complaint to the deputy commissioner as well as also chief minister, my lord. And my lord, may come to the page 54, my lord.
5-4,
54, my lord.
yes.
May I read, my lord?
Yes. No, this is the complaint. Then what has happened?
Complaint, my lord, no response. The complaint here, my lord, in paragraph, it has mentioned the shortcomings in the constructions of the building also, my lord. And their prayer is also, my lord, very limited to form a committee, my lord, to monitor the construction work, my lord.
Why is it required? Under what provision of law?
My lord, otherwise, my lord,
Is it required that all public works should be monitored by a committee to be instituted by a court or by the government. Government has their own agency. Unless you make out a case that something gross is happening, which would affect the public interest adversely.
Yes, my lord, because my lord, the construction,
Your contention is with regard to the water that we are not prima facie satisfied. Regarding curing, you have not, you're only making a statement will not do.
and the bar used for the, my lord, bar used for the construction building,
Bar means iron.
iron bar, my lord,
Yes. What is that?
is also not, my lord, as per the standard, my lord.
What materials?
My lord, like, my lord, at page 55 at their complaint, they specifically mentioned, my lord.
No, it's your complaint. Where is the materials to show that the bars are not in accordance with the standard? What bar they have used, where have you stated? And what is required, where have you stated?
In my lord, petition also I stated, my lord,
What is the iron bar which are being used?
they are using, my lord, 10 mm, my lord, for the filler, my lord.
Yes.
That is, as per the standard, my lord, required is, my lord, for G+2, my lord. They are construction G+2 building, my lord.
What is the requirement?
My lord, as per the complainants, my lord, that bar using by the,
It is 10 mm.
yes,
What is the standard? What is the standard?
my lord, it should be more than that, my
No,
lord.
no, where is the standard? You have to bring some literature. What is the standard? So you are not experts in construction.
Yes,
Neither
therefore, my lord, our prayer
neither
is,
you are. You have
Yeah.
to show some standard that for a G+2, the minimum, the strength of the bar should be this much mm.
yes, my-
What is the strength? What is the
but
standard?
therefore, we have lodged the complaint to form a committee, panel of
That's
expert,
not like
to,
that. PL, that-
my lord, monitor.
That's not the purpose of PR, to get everything monitored. You make out a case, we are with you.
Water sufficiency of the water use,
That is not a ground at all.
because, my lord,
You may have a ground in use of this bar. That may be an objective kind of an examination assessment that you are supposed to use 14 mm. For a G+2, you are using 10 mm.
Yeah.
Yes. But water, this is all subjective. How much water is being used, we do not know. Prima facie, you have from your photograph, we see that there is a sufficient reservoir being created.
Like,
Water is being transported from outside. Those cannot be excused.
my lord, curing of the concrete, my lord, it requires 7 days regular wet, my lord.
So if
So-
let's say a sufficiently big reservoir, how much big is the construction? What is the stage of the construction?
It's the beginning, my lord.
Beginning, so how much water will you need? Now only for the pillars. For curing, this is, I think, more than enough.
7 days to be, my lord, to be strong pillar, it's required 28 days, my lord. For that, my lord, running water is required, my lord.
Not required. Where do you get running water? You are supposed to water it 21 days, 3 times. That is what we know as a layman.
As per standard,
And if it is the same roof, then it has to be underwater for 21 days, and for which you need, it's not running, the concept of running water. There should be sufficient water to cure it.
and my lord, Indian, as per the standard,
And
my
where
lord,
do you get running water in a construction site where there is no water supply?
there's no water supply, my lord.
So where do you get, is it possible, suppose you are constructing this building, High Court building,
Yes.
there is no water supply. So can you abandon this project? You'll have to arrange for the water, they have arranged for the water.
Yes, my lord. There is a pH, before, my lord, starting the constructions, they should make the availability of water, my lord.
Your photograph shows that for water, they have got the water reserved. There's a reservoir, 2 at least, one is natural, one is artificial. On that ground, we don't think we are required to even issue notice. On the other ground, yes, use of bar, which is not of the standard. You have not even said anything about the quality, no allegation that substandard qualities materials have been used.
And, my lord, their allegation is when they ground floor, when they started the construction, on the deep
The
of the building below the earth, my lord, had to dig my lord, plinth, my lord.
Plinth.
Yes, my lord.
Plinth, yes. What has happened to the plinth?
That has also been opened within 2 days, which requires regular water for 7 days, my lord.
Mr. Nabam,
My lord.
not interested to issue notice at this stage. Mr. Tari, you have to, if you want to maintain your PI, you have to file better particulars.
My lord, first of all, my lord, to determine whether substandard material has been used or not. First, my lord, there has to be a DPR.
No,
What-
he has not said
Yes.
substandard.
My lord, he has said, my lord, the
No, no, he
construction
has not
building,
said.
my lord, we have
He has
used, my
said-
lord,
He has said first water and the second 10 mm.
10
What is
mm.
the standard, he doesn't know.
Yes, my lord. So that will be clarified only the DPR, my lord. Now, what DPR say, whether it should be used 10 mm or 16 mm, my lord.
Correct.
That also has not reduced, my lord. Under my lord, what expertise said, my lord, that we have used, my lord. He has not produced any document. And so far of storage of water is concerned, my lord, the photograph shows, my lord, some sort of stream running waters are there and we
We
have
grant
storage.
an opportunity. We are not doubting your bona fide. You are granting an opportunity, file an additional affidavit, bring materials on record
Material
to maintain your PI. Otherwise,
My lord, otherwise, my lord, we sought PL for PIL, but they have not furnished the copies of all these DPR also, my lord.
you have to.
No, no,
see,
RTA is there. You can have.
see, you have avenues in law. You apply under RTA. If you're not given, there are appellate provisions.
appellate provision.
You can come to a writ court if nothing is done by the appellate courts, appellate authority.
So then, my lord, let notice go, I'll file additional
No,
affidavit.
we're not issuing notice.
Let them file the additional
Notice is
affidavit.
not
If
for granted.
satisfied, then, my
In
lord.
a PL, that in a PL.
My lord.
Third, Tari. Run sometime. Learned counsel for the petitioners who have filed this present writ petition in the form of a PIL with regard to the construction of the mini secretariat building and other infrastructure at CZ,
Yes.
Lower Siang District. Full stop. Certain allegation of use of water which is not as per the standard for the concrete mixing, and also use of iron bar of 10 mm which is not as per the standards have been alleged. Full stop. However, the materials which have been annexed to the petition does not inspire enough confidence even to issue notice at this stage. Full stop. Para. Shri Nabam, the learned AAG, on the other hand, has also pointed out that the work has been done as per the DPR and the petitioner has not even done the due diligence exercise to bring the DPR on record so as to make out any case for issuing notice. At this stage, Sri Tari, the learned counsel for the petitioners, prays for some time to obtain further materials to substantiate the relief and to place, to obtain for, and place the same on record by way of an affidavit. Full stop. Para. This for motion after 3 weeks to enable the petitioners to file additional affidavit. We'll consider if you have a case,
Yes.
why not?
Well, all right.
The endeavor of all of us is to ensure that the quality of the building.
That will be at least maintained, yes.
Of the superior, the high standard.
Yes, ma'am.
Item number 2.
My lord, challenging the wires of General Arunachal Service Group C, multitasking staff common recruitment rules 2019 and 21, my lord.
Grounds?
Ground is that, my lord, it has restricted the promotion of skill to be regularized. So there are unskilled and the skilled. Which I, to my mind, my lord, it
Who
is a
the
hostile.
petitioner? Who is the petitioner?
Petitioners, they are all, they are the skill laborers in the skill contingent staff deployed in the Civil Aviation Department, my lord. And they were unskilled before, my lord. And thereafter they were given promotion as a skilled. But in this recruitment rule, the hostile discrimination on the part of the state is that they have regularized, my lord, one engineer who was serial number 14 in the seniority list of the common skill and unskilled level contingent staff, saying that the skill is not provided in the rules. 10B, my lord. So there, well, that's why simple prayer is, my lord. No further regularization of,
No, that is difficult.
no further.
There is an assumption of constitutionality of all enactments.
Correct.
But even if you are required to examine, you have to make it a prima facie case. Where is the case of hostile discrimination?
That I'll demonstrate.
Please
Kindly,
demonstrate.
my lord, kindly come to Annexure 6 straight.
Page
Please, 53, my lord.
5.3.
Yes, my lord.
Yes.
My lord, we'll see this. This is the combined interest. The combined interest seniority list of serving DLF staff, both skilled and unskilled contingency workers of Civil Aviation Department, has been prepared as directed wide office memorandum number so and so dated 13/7/2021 as per the date of appointment, my lord. Now here, my lord, the petitioner number 1, my lord.
Yes.
Petitioner number 1 stands as serial number 1. 10.
Taku.
Yes, my lord. Then serial number 8 is Tai Ana. Petitioner number 3, my lord.
10 is petition number 1.
Yes.
And
8 is petitioner number 2.
Diana. P2.
Yes, ma'am.
Okay, doesn't matter. Then
And
what is the
3.
case? Then tell us.
They are skilled, my lord.
The petitioners, you have told, the petitioners are all skilled.
My lord, first, their entry into the service is unskilled and they were given promotion as a skilled.
Hmm.
Now what happens is, my lord, now serial number 14, my lord, will kindly see. Prema Karbi, my lord. He is an unskilled man. They are all deployed in the ticket counters.
Petition number?
No, my lord, respondent, private respondent.
Where, serial number?
14, my lord.
40.
14, my lord.
14.
Yes.
14.
Prema Karbi, my lord.
He is respondent.
He is respondent, my lord. Even if my lord see, he is
Not
unskilled, we are skilled.
Okay.
Then the rule 2019 and further amendment in 2021, rule 10B, my lord, does not provide regularization of the skilled employees.
Let us see.
Kindly come. My lord, we'll have page 41.
41.
41.
Yes, please.
My lord, it says the notifications, they in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, and in separation of the common recruitment rules to the post of, my lord, will mark this common recruitment rules to the post of multitasking staff, MTS notified Y dated so and so 2008, except as respect things done or omitted to be done before such separation. The governor of Arunachal Pradesh is pleased to make the following rules to regulate the method of recruitment to the post of multitasking staff. Daftri, stroke barber, stroke cook, washerman, stroke cobbler, and equivalent post. Now the word is here, although they have used the word equivalent post, that means both skilled and unskilled staffs are group C in the form of multitasking, my lord. My lord, kindly come to page 44, the rules.
Yes.
Is a schedule here, my lord. 10. 10B, my lord, will see. B, 50% of the vacancies shall be filled up from amongst the existing unskilled contingency staff who have completed 15 years of service and who possess educational qualification of class 10 stroke ITI or equivalent pass certificate from a recognized board or institution, my lord. Here the word unskilled is not there, my lord. Skill is not there, my lord.
But this is a method of recruitment
Yes, my lord.
for the post, for those posts.
For 50% by direct recruitment, 50% by promotion. This is a reservation.
Yes. Now, this promotion would be to which post?
To the peon, my lord, regularization. There's peon, now it has been commonly named as multitasking staffs, my lord. And my lord, further,
You are working as what?
I am a little above unskilled. I am skilled.
No, you are skilled what?
Skill ticket countering and all.
No, it forms under multitasking.
From the
No,
multitasking.
you are in the cadre of multitasking.
No, but is now all those staff, my lord, peon, mali, cook, chowkidar, everything, they are commonly rechristened as a multitasking staff, my lord. Multitasking staff. So initially, I am unskilled contingent staff, my
No,
lord.
that you have understood. What is your status now? You are,
I'm skilled,
no, skilled, but you are not regularized.
not regularized.
So this, you say that this, under column number 10, you get an avenue for yourself to be regularized?
No, I don't get.
No.
Yes, sir. So-
The
Sir.
skilled or unskilled,
yes.
you are making a distinction between skilled and unskilled, but as a contingency staff, 50% is reserved for your category, but they have only limited to unskilled staff.
Unskilled, you know, that's great. Well, and my lord, kindly see the hostility in the next recruitment rule, my lord, page 46, amendment, my lord. 13 July.
46.
Page 46, my lord, serial number 2, my lord.
What is this?
Yes, my lord, 46, 46.
Yes.
My lord, kindly see amendment to the schedule of the principal rules. In the schedule of column 10 of para B for the existing paras, the following shall be substituted. 50% of the vacancies shall be filled up from amongst the serving unskilled contingent C staff, stroke, auxiliary labor corps, ALC, casual laborers with minimum 15 years of continuous service in their respective offices, departments, and possessing educational qualifications of class 10 so-and-so or equivalent pass certificate from a recognized board or institution. The selection shall be made on the recommendation of departmental selection committee on the basis of the seniority. My lord will see that annexure 6, which I referred to. Seniority, performance, punctuality, and integrity certificate. The candidate who do not possess aforesaid requisite qualifications and appointment prior to 1st June 2010.
Okay, Mr. Akan, what do you say?
Notice may go, my lord.
No, but notice is okay, but why is a distinction between skilled and
That I will-
unskilled? Skilled, we presuppose that they are on a slightly higher footing.
Higher foot.
You are trying to exclude them from the avenue of being regularized.
Yes, madam.
Is it a mistake or what?
Whether it's a mistake or whether the post of multitasking staff itself,
But then excluded here.
whether the post of multitasking staff itself is equivalent to skilled, that we'll have to take instruction, madam.
No, whether it's skilled or unskilled, you have enacted a set of rules in 2019,
Yes,
whereby you have laid down that 50% of those posts will be filled up from the existing staff.
interesting.
And you have limited those existing staff only to the unskilled,
Unskilled,
whereas the petitioners, they
are skilled.
are skilled.
Yes.
And they, obviously, they stand on a slightly higher footing.
Higher,
In fact, the preference should have been given to them first.
yes.
Normally.
No.
Tell us probably what will be the impact, we do not know, but okay, we should notice at this stage.
Yes,
My lord, I'm making a small interim prayer because, my lord, prima facie, the principle which I am pressing before. my
No,
lord,
is there any impending move to promote?
Yes, my lord,
When?
likely, my lord, because they
When-
have been asked for the APRs and all.
if there is a move, you file an IA, we'll consider. But Mr. Ratan,
Yes,
if you are actually going ahead with some promotional exercise, you allow the skilled also to participate.
yes, yes.
It can be made subject to the outcome.
And my lord, will recall
But
that
you take the instructions.
I'll take
Right
that.
now, we are not passing any such order, but
Yes.
that is what we can do to
My lord-
balance the equity.
My lord, may I observe that in the event any move for,
They can come.
yes,
needless to say that.
yes.
What is your instruction? Is it required?
No,
Is it there?
I have to take instruction. ma'am.
Okay.
My lord, that
Sri
Purushottam,
T. Tara, learned counsel for the petitioners who by means of this application has questioned the vires of the so-and-so rules of 2019, which have also been amended in the year 2021. 21 amendment?
Yes.
Full stop. Specific contention is that the mode of recruitment, which includes, which consists of two parts, including 50% by promotion, has been restricted only to unskilled staff, whereas the petitioners are skilled contingent staff in the department. Full stop. Para. That notice be issued, returnable on. And Mr. Ratnam, tell us.
My lord, let it be after 4 weeks, my lord.
Why today is 5th.
5th.
We can have it on 6th of March. Is it okay?
fine, my lord.
6th of March. Sri N. Ratan, learned AG, accepts notice on behalf of respondent numbers 1, 2, 3,
And 4.
and 4. Extra copies within 2 working days. 5 speed posted AD within 2 working days. We're not saying anything. You come.
My lord,
If there is any impending move.
My lord, may I only make a small request to my lords, if my lord can make any small observation to an extent that any further regularization of the MTS staff on the basis of 2019 and 21 rules shall be subject to the outcome of.
It's already there.
My lord, kindly,
More than that, we would have said something more for you, but you come up. We'll make an observation that if such an exercise is
correct.
is taken up, you should not be excluded for the time being. We'll make that observation,
Correct.
but the learned counsel for the petitioner is at liberty to move this court by an aye if there is any impending move to carry out a regularization exercise.
Obliged.
Item number 3.
So, Mr. Sakya, for whom?
And I am for the petitioner, my lord.
Union?
Union, my lord.
What?
My lord,
Ministry of Road Transport?
no, my lord, CAG, my lord, Arunachal chapter, my lord. Auditor, Principal Auditor General, my lord.
What is your, where have you filed a petition?
My lord, challenging the order of the Kate Guwahati, my lord.
KT.
My lord.
Okay, yes, madam.
Lordship, we have, I'm for respondent number 1 appearing on behalf of Mr. M. Chanda. We have filed an affidavit in opposition. As per the last order, respondent number 2 were supposed to file the affidavit in opposition. As per the office note
You're
dated.
for 2.
Yes, madam.
Would you like,
Staff selection board, madam.
okay, would you like to file affidavit?
My lord, the affidavit, yes, madam. Will file affidavit, madam. Altogether, my lord, 4 candidates were found to be disqualified as per the advertisement, madam. So therefore, my lord, after re-verification, my lord,
Or Sri R. Sakya, learned counsel for the petitioners. Full stop. Miss N. Anju, learned counsel for the respondent number 1 has submitted that affidavit in opposition has been filed. Full stop, Clara. Sri M. Kato, learned Deputy SGI, appearing for the respondent number 2,
Right.
has renewed his prayer for grant of time to enable filing of affidavit in opposition. Full stop, para. In view of the above, matter is adjourned to 27th of February, by which time the affidavit in opposition by the respondent number 2 is required to be filed. Para. Interim order passed earlier to continue till the next date of listing. Fix the date 27th.
Lodge.
What is the other WP? 41? Oh, very good. Okay.
I think two looks better.
Those days, no? So,
Item number 4.
Yeah, please, Your Lordship, I am appearing for the appellant as a legal aid counsel, Lordship. TCR was called for and I see that TCR has been received. So maybe directed to prepare the paper books. Lord.
okay.
Paper book.
Okay. Heard Sri J. Ginny, learned legal aid counsel for the appellant. Also
G-
heard
G. Tado.
G. Tago,
Yes, additional PP.
learned additional PP for the state of Arunachal Pradesh. Para. Pursuant to earlier orders passed by this court, the trial court records have been received. Para. Registry is directed to prepare the paper book and list the same thereafter to fix a date of hearing.
Published.
Please, they will take place immediately there. Fix it.
Item number 5.
5.
May it pleases your lordships.
Wait.
My lord,
Yes,
yeah, in
Just a
this PIL already notice is being issued, but reply is not yet filed, lordship.
what is
This
the
is for
PIL about?
this PIL is about implementation of Integrated Child Development Services Scheme, lordship. As there is the study which the
Your Lordship.
petitioner
Yes,
has made in
Yes, yes, what
certain
is
areas.
What is your take?
I'll be needing some more time, Your Lordship.
25 matter, okay, file it.
Yes,
The important issue has been
Yes, Your
raised.
Lordship.
And lordship, even as per the NFSA Act, lordship, each and every day a child not getting food, lordship.
For the petitioner appearing online, Para. Sri Learned State Council has renewed his prayer for grant of time to file the affidavit in opposition. Para. Considering the issue involved, the response of the state would be necessary. Accordingly, further time of 4 weeks is granted to the state, by which time the affidavit in opposition is required to be filed.
Yes, sir.
Lordship, may it be 3 weeks, I'll be, and date may be fixed, lordship, on, if possible,
We'll
on
fix the
25th of February, lordship.
25th will be less. We'll fix a date on 6th of, on 5th of March.
Yes,
5th March.
Yes, sir.
Deeply obliged, lord. Deeply.
Item number 7. Lordship, paper book is prepared.
Legal counsel.
Yes, Lordship.
Where is Mr. Darang? Any friend of his, Mr. Darang?
She's not present today, Lord.
Paper book is prepared. None appears for the petitioner, for the appellant on call. Full stop. This court has, however, been informed that the learned legal aid counsel appearing for the appellant has submitted a letter of absence in advance. Full stop. Also heard Ms. L. Hage, learned additional PP, Arunachal Pradesh, who has submitted that paper book has been prepared. Full stop, para. In view of the above, is there any private respondent?
Lordship, no lordship, only state lordship.
Okay. In view of the above, the appeal is to be listed for hearing in its course,
Lordship. Much obliged.
in its turn. On its turn.
Item number 8.
My lord, in this
Yes,
case, my
Power
lord,
Department is the appellant.
my lord,
Power Department is the appellant.
no, my lord, the education department, my lord.
Yes, what is your problem?
My lord, here, although we have taken a step upon the respondent, my lord, it seems that it has not been returned, the service report has not been returned back, my lord.
Sole respondent.
Yes, my lord.
Sole respondent is the writ petitioner.
Yes, my lord.
Who was appearing for the writ petitioner?
Earlier, they were represented by, he was represented by Tafor, Peter Foreman.
Can you ask him? He can take the instructions if he's appearing.
My lord, I'll talk to him, my lord.
You talk to him?
Yes.
Okay, because this, he had taken steps in July 2025. We are
Yes.
in February 26.
My lord,
Till now, there is no conformity of the service.
my lord,
So if he is instructed to appear, we can ask him.
my lord. I'll talk to him, my lord.
Okay, we'll adjourn by a week.
My lord,
In the meantime, talk to him, ask him
Yes.
to come.
my lord.
Okay. Heard Sri T. Tagum, Learned Counsel, Learned Standing Counsel, Education Department appearing for the appellants. In view of the office note dated 4/2/2026 regarding on the aspect of service of notice upon the sole respondent, matter is adjourned by a week. List on Wednesday next.
My lord.
Item number 9 to 13.
My lord, item number 9 is an IA for condonation of delay of 41 days. Service report on the respondent. Here only one respondent, private respondent, is still awaited.
Who is there?
No, my lord, I appear
I-
for the other items,
The other items from 10 to
10, 11 and 13.
10, 11 and 13.
No, 9 is connected with 10.
Yes,
So-
all arises out of the 4 appeals.
No, my lord, 9 is out of writ appeal number 49, that is item 12.
Item 12.
9 is in 12. In my writ appeals, my lord, the delay has been condoned.
So here, who's appearing in
Here,
one?
earlier, Mr. Parme was appearing for the petitioner, my lord, the writ petitioner. Now still they have not received.
But in view of the office note,
AD card.
ID card, neither ID card. If it is served, they are not appearing, we can take a call. But now we have
Yes.
to ensure that notice has been served.
Yes.
Mr. Dubey, you are appearing for somebody?
Yes, Mirza, I appear on behalf of Airport Authority of India and the Regional Executive Director. They have been made pro forma respondent in all this.
Okay, you may not have an objection in this delay
No, no, no.
condemnation.
No, Lord, I
What
don't.
about the writ petitioner? We want the writ petition with the contesting respondent here.
I don't know why
Who had appeared earlier?
Mr. Parme, Liz L. Parme,
Elper, where is he?
he is not available today.
You try to contact.
They have
him.
filed a contempt, but they are not appearing in this appeal.
Yes, my Lord, contempt proceeding has been filed.
But we need to.
Yes, my lord, we will take fresh steps.
No, no, you ask him to, we'll release this case again on Wednesday next. Inform him.
Yes.
If
In
he
fact-
can accept notice, then we condone the delay. If he says that he has no instruction, then we'll explore the other option of serving dusty or whatever, okay? And Mr. Yes, what do you say, Mr. Nair?
My lord,
Heard Sri and Ratan, learned AAG appearing for the applicant. This is item number 9, huh? Applicant who has filed this application for condonation of delay of 41 days. 41 days.
41 days.
41 days in preferring the appeal. Full stop. It has been submitted that in the connected, this application has been filed in connection with WS 49.
49.
49 of 2025. Full stop. We have also been informed that so far as the other appeals are concerned, the delay has We can condone the delay. Other appeals,
Yes.
other appeals delay has been condoned.
He has also no objection.
No, he's not the contesting respondent here.
Yes.
No, LL permits contesting respondent. He's not served. Okay, next to it. We have been informed that in the other appeals, the delay has been condoned. Put the para in the interest of justice. Let another opportunity, in the interest of justice, matter is adjourned to be listed on Wednesday, when this court will consider the aspect of condonation of delay. Wednesday.
Obliged.
You can appear online, no problem.
You'll also record my
Sri-
presence.
Sri R. Dubey, learned counsel for the Airport Authority of India, who is which is the pro forma respondent, has appeared online.
Malad, I am for the Union of India, man.
Sri M. Kato, learned deputy HJ, is present.
Item number 14.
IA for Mr. President.
My lord, this is for condonation of delay of 453 days, my lord.
Coming for the first time.
Yes, my lord.
You will issue notice of this.
Yes.
Is there any private respondent?
Yes, my lord.
Yes, to go. Heard Sri N. Taje.
Yes, my lord.
Learned counsel for the applicant who by means of this application filed under Section 5 of the Limitation Act 1963 has prayed for condonation of delay of 428 days in preferring the connected criminal appeal. The appeal has been preferred against the judgment and order that so and so passed by so and so. Correct? That notice be issued, returnable on 9th of March 2026. Ms. So and so learned APP accepts notice on behalf of respondent number 1. Let steps be taken for service of notice upon the respondent number 2. How do you take steps in?
Your Lordship, they
For
can
you?
through our office, Your Lordship.
For as well, which is to be routed
Through
to
the office,
office of the learned
public
PP,
prosecutor.
Arunachal Pradesh. Steps within 2 working days.
Obliged.
This is involving POXO.
Yes, it's a POXO.
Yes.
Okay, single bench in 5 minutes.
May your lordship. Your lordship, I beg to mention item number 11. Here, the main counsel is from the out of station due to some personal difficulty. He is not able to be present here.
Item number
11.
Who's the counsel?
Counsel is P. Bora.
For the petitioner.
Petitioner, yes, you know. And I have also taken a concern from the government side also.
When do you want?
You know, matter may be fixed on 13 of this month.
13th.
13th.
13th it may be difficult. You'll have it on 16th.
16th, okay.
Okay.
Okay, deeply obliged.
A prayer for adjournment has been made on behalf of Sri P. Bora.
P. Bora.
Who appears for the petitioner. Para. Accordingly, matter is adjourned to be listed on 16/2.
Deeply obliged.
Yes.
My lord, I beg to mention item number 8 on the behalf of Tatak, my lord.
Yes.
Said conducting counsels out of station due to domestic problem, my lord.
Okay, when we fix this?
Yes, my lord, this matter may fix last week of this February, my lord.
Okay. On a prayer made on behalf of Sri Tatak, learned counsel for the petitioner, matter is adjourned to be listed on 25th of February. Okay, 25/2. Yes.
May I please? Your Lordship, I beg to mention one unlisted matter, that is WPC number 10424. Your Lordship, this matter may be listed on 17th February.
17. What is the matter about?
This is.
Why do you want an out of turn listing?
Pardon, Lordship?
Why do you want an out of turn listing by a mention memo? Is there any urgency?
Your Lordship, yes, Your Lordship.
What is the urgency? You need to know out of turn listing by a mention memo, there has to be something urgent. Otherwise, matters are getting listed by the registry. Make it a case for urgency, we'll allow it. If it is a motion matter is different. If it's an existing matter, there has to
Actually,
be something.
Your Lordship mentioned is made on behalf of the TAPAC.
That is not enough. You come prepared what is the urgency, then we'll consider, okay? Not like this. Come tomorrow or come prepared. Yes,
My lordship, may I beg to mention item numbers 13, my lordship.
1-3.
Yes, my
Yes,
lordship.
what is it?
We need some more time to file an affidavit in this, my lordship.
Here for whom? For the
For
state.
respondent number 1 and 2.
Yes, Mr.
My lord.
You have not filed affidavit.
No, ma'am.
2 weeks may be given, my lord.
Part 3, R. Saikia, Learned Counsel for the petitioners, para. Ms. So-and-so Learned State Counsel has however renewed her prayer for grant of time to file affidavit in opposition, para. List, matter accordingly stands adjourned to be listed on, we give a date, madam? The 2nd of March. We're giving enough time, 5 days before this.
Okay.
2nd March. No interim order, I think, existing.
No interim order.
May I please, Your Lordship? I wish to mention item number 5.
5.
Yes,
Yes,
sir.
what is it? Yes.
The standing council of the tourism department is not feeling well, Your Lordship.
Is it in the court?
No, Your Lordship.
Oh, wait, this matter has to reach. It's a 15 matter. We're not going to adjourn this matter. We'll take a call when the matter reaches. 10 years have passed for a petition is very embarrassing. Yes, Mr. Pani?
Yes, I am for a petitioner.
You have seen it.
Yes. This was in fact heard, this honorable court, but this honorable court felt that 2 other persons said to be met party. So in the meantime, my lord, I have
Let
instructed.
it reach.
Yes.
Let it reach.
Right.
We may accommodate
Yes.
his prayer, but not immediately. Okay.
May, my lord, I beg to adjourn item number 9 on the behalf of standing council.
You
of-
beg to adjourn. You
Yes.
adjourn it.
Item number.
Who's stopping you? Yes, what is it? Item number?
Item number 9 on the behalf of Senior Counsel G. Tarak, Standing Counsel of RWD.
Okay, Madam Dungan, you're for the petitioner.
Yes, my lord, in fact, one of my colleagues was looking after
Handling.
this. Yes,
Okay, singing time.
yes.
How much time?
After 2 weeks.
File affidavit.
I
Have you filed the affidavit? Madam?
Your Honor, my senior counsel only instruct me that's it.
I
You should
think
know
they
whether-
file affidavit.
These are not so difficult.
Oh, yes, yes, Your Honor, yes. I've
Affidavit filed.
yes.
Okay. You would like to file rejoinder affidavit?
Lordship, if,
You're also not very sure.
yes, I'm also not sure, to be frank.
Okay, on a prayer made on behalf of Sri G. Tarak, Learned Standing Council, RWD,
RWD,
matter is adjourned to be listed after 2 weeks.
yes.
All right.
Yes.
May I, Lordship? I beg to mention item number 4.
4, yes.
Pray for the adjournment of the matter, Your Honor.
Why do you seek adjournment motion matter?
Actually, Your Honor, the leading counsel was present in the court premise, but due to some unfortunate emergency, he left the court.
Okay, who's the council?
T. Topo, Your
State of- oh,
The
okay.
matter,
On a request made on behalf of the petition, made on behalf of the petitioners.
Your Honor,
Matter is adjourned to be listed when?
tomorrow. Your Honor.
Tomorrow?
Yes.
Tomorrow, okay,
Much appreciated.
tomorrow. Please give the date and get it signed immediately, huh? Yes.
My lord, in item 10,
Yes.
we were supposed to file an affidavit by respondent number 2. But
Yes.
some more time may be given, my lord.
Item 10, okay.
Yes.
On a prayer.
Lordship, in this case, by the last order, that is 25/9/25,
Hmm.
3 weeks time was given.
Hmm.
In fact, the matter was heard, but this honorable court was
We'll
of the,
grant, sometime, but we'll fix a date, don't worry.
yes, Lordship.
On the prayer of Sri N. Ratan, Learned AAG, further time of 10 days is granted to enable filing of
At least-
affidavit in opposition.
2 weeks, my lord.
Further time of 2 weeks.
Lordship, already 3 weeks was given. It expired in November itself. Now it's more than 4 months.
So, Ms. N. Dungan, Learned Counsel for the petitioner, has however pointed out that in the meantime, sufficient time was granted to the state to file the affidavit, which has not been done. Full stop. Para. Be that as it may, the matter stands adjourned to be listed on 23rd of February, by which time the affidavit in opposition is required to be filed. 23rd, madam?
Obliged.
Yes, 23rd February. Is there an interim order?
No.
Mr. Kato?
My lord, may I pray, my lord, some accommodations in item number, my lord, 21, arbitration matter, my lord. In fact, I have taken the consent of the other party also, my lord. After 2 weeks, my lord.
21 is a hearing matter
My lord.
for our appointment.
No, my lord. The order passed by the learned, my lord, the trial court. We are, my lord, basically selecting the, my lord.
37 appeal?
Yes, my lord.
It's an appeal?
Yes, my lord.
Okay. Other side informed?
Yes, my lord.
Okay. Sri M. Kato, learned deputy AGI for the appellant, has prayed for an adjournment. Full stop. Your
It's Kajama.
HK Jammu, learned counsel for the respondents is present. Both the respondents
For the rest.
is present. Para, when tell us the date of your convenience.
My lord, after,
As agreed to by the learned counsel for the parties,
2 weeks.
based on, we give a date. As agreed to a list for hearing after 3 weeks.
my lord.
Okay.
Slip the. My lord, I'm sorry, my lord, there is interim order that may be cut.
Then we give a date.
My lord.
Don't say 3 weeks, list on. We'll have it on 10th of March. 10th of March. Interim order passed earlier to continue till the next date of listing.
Leave them.
Item number 1.
Yes, Madam Jetli, what brings you here?
Please, Your Lordships. My Lord, in fact, we have a factory, my Lords, in the East Siang district, in the IGC area, Your Lordship. This is the Industrial Growth Center. This is given by the central government. We have all the
What is your
requisite.
grievance? This has not come up for the first time.
No, my Lords. In fact, we had filed it in November. Since September, Your Lordships, our ingress and egress had been blocked by the local villagers, Your Lordships. There is a matter which is already pending in NGT. In fact, one of the private respondents who was impleaded on the last date of hearing, and he had made a statement that his protest is peaceful. So we said that we will start and continue with our operations and movement of the trucks. But even thereafter, Your Lordship, our trucks have been stalled. So our request was only.
Mr. Mehdi?
Lordship, I am for the private respondent number 5, Lordship. Lordship, we are one of the villagers, Lordship, and we have formed a group, and we are objecting to the pollution that has been created by the petitioner.
Factory.
Okay. And Lordship, the matter is pending in NGT. It is to be yet to be decided, Lordship. In the meanwhile,
NGT, you are the complainant.
No, Lordship.
Somebody else.
No, Lordship. If I may be allowed, Lordship. What has happened is this, that we had made a protest. These are the group of villagers who are doing the protest and taking cognizance. When this matter came in the knowledge of the Honorable NGT, Suomoto, they took cognizance. Okay. And Lordship, this matter is pending in the NGT. Lordship, in the meanwhile, we went there and wanted and we filed an IA. We wanted us to get implemented in that matter. Then by order dated 18/11/2025, Honorable NGT, they observed that we can come again by way of filing of an original application, and Lordship, that original application will be clubbed together with the pending original application. Lordship, we had filed our OA and it is yet to be listed, and perhaps Lordship, on the next day when the matter will be listed, it will be clubbed together. In the meanwhile, my learned senior, as she has said that she has a grievance that she wants to run a factory. We have no objection to it, and in fact, Lordship, we have not done any obstruction to her activities. Lordship, our protest, our peaceful protest, we are doing 4 kilometers away from the industrial site, Lordship.
No, your protest is qua the activities of the present petitioner.
Yes, present activities, Lordship, to the effect that they are causing pollution, Lordship.
This petitioner.
Yes, Lordship. Yes,
not
Lordship.
for anybody else.
Not for anybody else.
Is directly connected with this establishment.
Yes, directly connected with the establishment, but Lordship, our way of protesting is very peaceful, Lordship.
That we are not on that.
Lordship.
We wanted to ensure that whether your protest is directly connected with their
Yes, Lordship.
or some other activity.
No, their activities.
We have understood that your protest is a peaceful one, which you are doing some distance.
4 kilometers away, Lordship, we
There
have,
is no obstruction as such.
Lordship.
Madam, Mr. Ratan, what do you say? Now, even now, they are not being able to run.
My lord, in fact, they say that their protest is peaceful, but
Respondents.
yes, private respondent, but in fact, they have obstructed the trucks and all of the factory, for which there was deployments of force also.
Yes, no, you see, it's a law and order problem.
Yes.
You have to tackle it. It's you are the
Yes,
state.
my lord.
See, there is no interim order either by the tribunal, and the unit is before us. So unit's grievance, at best we can say that we can reject it. It will not give an order that the protest is legitimate or the industry is not. That may be decided by the tribunal.
Yes.
In the absence of any interim order passed by the tribunal, there should not be a bar for them to go ahead with their activities.
Yes, madam.
We could have understood if there is any restraint order by the tribunal, the Green Tribunal, NGT.
Yes, my lord.
And this is at the stage of notice.
Yes.
So
We have filed our affidavit also, but
We have also filed our counter affidavit.
you take steps in view of the statement made by Mr. Medhi that they are not obstructing.
yes, my
And they
lord,
would-
that may be
they would
recorded
rather
and
abide by the orders that may be passed by the tribunal.
yes. My lord, that may be recorded and it can be disposed of, my lord, at this stage.
Lordship, I have one more submission, Lordship. Lordship, in the meanwhile.
No, we may not dispose of. We'll issue notice. We'll make some interim observations.
Yes.
Okay, because we don't want to, there shouldn't be any overlapping of
Yes.
matters. Our orders should not come into the way of the NGT also.
Yes.
So let it be
Only
pending.
issue is only the law and order problem, my lord.
Lordship, I have one more submission. Lordship, I want to appraise this honorable court that day before yesterday, we have received one notice from the executive magistrate, East Siang district, Ruk Singh subdivision. And Lordship, as I'm being informed, today we have went there and we are replying to the show cause notice, Lordship. And I think the executive magistrate is making some kind of inquiry. So let the
Regarding
inquiry be
your
complete.
activities, that whether you are.
Yes, Lordship. So let the inquiry complete, Lordship, and then Lordship can take a call.
Since you are making an undertaking that you are not.
Yes.
We will record
That's I'm
that.
appraising this honorable court, Lordship.
Heard Miss G. Jetli, learned counsel for the petitioner. Full stop. Also heard Sri N. Ratan, learned EAG, and Sri P.P. Medhi, learned counsel for the respondent number
5, Lordship.
5, who have in the meantime entered appearance pursuant to earlier orders which were passed pre-motion. Full stop, para. As per the facts projected, comma, the petitioner, which is an LLP, is engaged in manufacturing ferrosilicon at the Industrial Growth Center, Niklok, Gorlung, in the district of East Siang, and is aggrieved by the illegal obstruction and blockade caused by some protesters. Full stop. The grievance of the petitioner is also with regard to the failure of the state authorities to maintain public order and ensure unobstructed access to the lawful to the premises of the petitioner's lawful business. Full stop. It is contended that the factory was established by obtaining all the requisite statutory permissions. Full stop. This court, however, has also been informed that on the issue of causing pollution by the industrial unit, there is a suo motu proceeding taken by the NGT on the basis of certain protest lodged by the private respondents. Full stop. Subsequently, Sri Mehdi, the learned counsel for the respond number
5, Lordship.
5 has also informed that an implementation application was filed by his client in the NGT, and on 18/11/2025, an observation was made that the aggrieved party may file an original application, which has been accordingly done and is tagged with
It is yet to be listed, Lordship.
and accordingly done, and the same is to be listed along with the existing OA.
Yes, Lordship.
Is to be listed.
Is yet to be listed.
Is to be considered. Is to be considered along with the earlier OA. Full stop. Para. Not para. Sri Mehdi has also informed that as per instructions received, the issue of law and order has been taken up by the
Executive Magistrate.
Magistrate, and some steps were being recently taken. He has, however, informed that the protest led by his client is a peaceful one, which is at a distance of 4 kilometers, and they have not obstructed the petitioner in their present activities of running the factory. Full stop. Para. Sri N. Ratan, learned AG, has informed that all necessary steps have been taken for enable the petitioner to run the unit. Para. In view of the above developments, let notice be issued. Returnable on, we give a date, madam?
Lords would consider giving it after the NGT, which is on
When
6th
is
of
the
April.
NGT?
6th of April, Your Lordship.
6th of April. Okay, we'll give.
Well, I'm unavailable till 27th of April, so if it could be any time after that, Your Lordship.
Returnable on 30th of April,
I'm deep.
2026. Who will be accepting notice? Sri Ratan, the learned AG accepts notice on behalf of respondents 1, 2, and 3.
3 and 4.
Where are you, Mr. Meji?
I'm 5, Lordship. Respondent.
Newly implemented.
Newly implemented, Lordship. On the last date itself, we were implemented.
2, 3, and 4. Whereas Sri PP Meji, learned counsel, accepts notice on behalf of the newly implemented respond number 5.
5.
You have been already given extra copies, I think?
Yes, Lordship. In fact, we have filed our counter affidavit also.
It also appears. Yeah, have you also filed your counter?
Yes, ma'am.
They filed action taken reports, madam.
This court has also noticed that the contesting respondents, respondent number 5, as well as the state, have filed their response. Full stop. The state has also filed an action taken report. Full stop. Para. In view of the full stop. Para. Ms. Immediately, the learned counsel prays for an interim order, Para, in view of the fact that there is no restraint order by the NGT till date, and also the undertaking made by the respondent 5, includes coupled with the action taken report. It is directed that till the returnable date, the official respondent will take all necessary steps to ensure that there is no obstruction in the ingress and egress of the man and materials of the petitioner to their factory premises.
I'm deep.
I'm obliged.
We will also file a rejoinder, Your Lordship.
By the next date, further pleadings may be exchanged.
I'm obliged, Lordship.
What is this IA? IA is your, I think,
Yes,
implement.
implement IA.
I think disposed of.
It is disposed of on the last date, Lordship.
There were 2 orders on the last date, my lords, one in the IA.
Okay.
325, my lord.
Door 50 met here.
Item number 2.
Item 2, yes.
Yes, for arbitration, appointing of arbitrator.
First time it has come.
Yes, Lordship.
Where is the clause?
Clause, page number 19, Lordship.
19.
Yes. Clause 7.
Okay, I think you have moved a similar petition day before yesterday.
Yes.
Okay. Heard. Your T. Gyatso.
Yes, Lordship.
Sri T. Gyatso, learned counsel for the petitioner who has filed this application under section 11 of the Arbitration and Conciliation Act 1996 for appointment of an arbitrator. Full stop. The learned counsel has drawn the attention of this court to the contract between the parties, including clause 7 thereof, which is with regard to appointment of arbitrator for settlement of disputes. He has also referred to the representation for such appointment which has not been acted upon. Sarah, that notice be issued.
Yes.
Returnable on, we give a date on 9th of March 2026. Mr. Long, here for all?
All.
Three so-and-so learned, so-and-so State Council for all the respondents. That extra copy is
Yes.
within 2 working days.
Keep problem.
Item number 3.
Somebody?
My lord, we are 3 in numbers. The petitioners are 3 in numbers.
Yes.
Here, my lord, we are aggrieved against the order passed by the SDO on 29/1/2026 and 2nd February 2026.
Yes.
Those are the similar orders, whereby, my lord, activities over the land, as we have the land of the LPC, and over that the LPC has been
Lord, the activity over your land has been restrained.
restrained.
That is your grievance.
Grievance, and
What is the reason cited?
at the same time, I'll show the lordship. May I kindly come to the page number 23. That we have not only been stopped, but at the same time, the police was also directed, OCPS Doimuk is directed to visit the spot and seize all machines and the labors if found in the spot and book under the relevant section of the law.
What is the ground?
Ground is only that some private respondent has complained, and I will show the lordship to kindly come to the page number 30, lordship.
But you don't go ahead with any.
Ground is only that there are some other person who has complained that there is a certain dispute over the land. In fact, there is no any dispute. My submission would be that there is no any land dispute
But
between
Mr.
the
Modi,
parties.
if a complaint has been filed and that is adjudicated by the appropriate authority, should we interfere at this stage? See, there can be a complaint against your LPC. The complaint may have merits, may not have merits. It would be adjudicated by the appropriate.
Exactly, my lord. Until and unless that complaint has not been adjudicated, that is the competent authority is the deputy commissioner.
Ask you to restrain any construction activities. That will remain, but seizure of materials, we can restrain that, but do not go ahead with construction. Yes, who is appearing?
My lord, may I kindly see page number 30, my lord.
What do you say?
Actually, this portion of land, dispute is going on. And that is pending before the one who issued that.
You do not seize the material, the materials and the equipment.
Yes.
But we'll direct that he'll not carry out any activities.
That's right.
Till the next date. Okay? We'll try to balance the equities in view of a complaint being filed. Let the complaint be adjudicated. Who are the complainants?
My lord,
They have been made parties or not?
yes, my lord, they are a party here, my lord. They are in the name of
parties?
Page number 30, my lord.
Okay.
My lord, got it?
Chairman representing
My lord.
EVYCA.
Yes, my lord.
What is
SSB, my lord, higher heavier catchment area committee welfare, my lord. But despite that, my lord, chairman is,
Now, what is DVYC means?
my lord, the DBYC mean, my lord, the Debra Village Welfare Committee.
Debra Village Welfare Committee.
My lord.
So the committee is against you.
My lord, this is why I'm trying to demonstrate the lordship that in the page number 30, my lord will find.
You are a rebellious
Even the,
rebel in the village.
even the president has not put his signature, my lord. What my contention is,
Who is this husband number 4 then? He's the chairman.
my lord. So, my lord, we are the, my lord, that's having LPC.
Third, Sri C. Modi, learned counsel for the petitioners. Full stop. The petitioners, who are 3 in numbers, are aggrieved by the action of the who has passed
SDO Doimuk.
in the form of orders dated 29/1/2026 and 2/2/2026, whereby the activities over the land of the petitioners have been restrained. Full stop. It is also ordered that the machineries and equipments on the spot should be seized by the in charge of the Doimuk police station, and the labor be booked under the relevant provisions of law. The petitioners claim to be lawful holder of LPC over the plot of land in question. Para. Let notice be issued, returnable on, we give a date on 2nd of March. 2nd of March 2026. Sri Swansea Learned State Council for 1, 2, and 3.
3, yes.
Extra copies 4, 5 by speed post with AD, steps within 2 working days. Full stop. Para. Sri Modi, the Learned Council for the petitioners, praise for an interim order. Full stop. Sri Long, the Learned State Council, has however informed that it appears that the order has been passed on a complaint lodged by the private respondents, which is under consideration. Para. Considering the above and balancing the equities, while this court will not pass any orders. This court is of the opinion that while the petitioners can be restrained to carry out any further activities over the plot of land in question, the order pertaining to seizure of the machineries and equipment and also booking of the laborers under the appropriate provisions of law by the concerned police station shall remain suspended. The aforesaid interim order shall remain suspended till the returnable date. The aforesaid interim order, however, would be reconsidered on the returnable date.
Item number 5.
Yes. 5 is 15 matter, yes.
Yes, Your Lordship, the Standing Council of the Tourism Department is.
To say something, there
Yes,
is development.
We have challenged the promotion that has been given before completion of the qualifying length of service. They would have affected me in the post of district tourism officer. Now the provisional seniority list has been issued, wherein I have been shown senior. So that may take care of my grievances.
Okay.
I will take instructions, my lord. It has not been finalized yet.
No, we'll record and we'll close this 15 matter. We'll have it on Monday then.
Monday, my lord, in that case. Because if it is not finalized, I may have to-
while a prayer for adjournment has been made on behalf of Sri Npada. Npada, Learned Standing Council, Tourism Department, Sri Deepami, Learned Council for the petitioner, has informed this court that there are certain instructions which may be towards resolution of the dispute. He, however, has prayed for a little accommodation to take further instructions in this regard. Para. considering that this writ petition is pending since the year 2015. A slight accommodation till Monday next is granted.
Can be, my lord, Tuesday, then.
Till Tuesday next is granted. Full stop para. List on Tuesday next. Please give the date. 10th.
Oblige, my lord.
Oblige.
Item number 6.
My lord, this is non-payment of admitted amount. My lord, initially,
Where is he go? Asking to be here.
Yes.
Yes, item number 6.
yes.
Yes, please.
My lord, Lordship may come to page 19 of my writ petition, annexure 1. This is the initial, my award letter. I was awarded as the PDS carriers contractor for this West
Affidavits have been exchanged.
exchange. But India,
For whom?
My lord, I am for respond number 1, 2, and 3.
Education department.
Yes, my lord.
What is your stand?
My lord, my state, my lord, this, the claim, the amount which is claimed is, my lord, it's not the correct, my lord. Moreover, my lord, that project was implemented earlier by the supply department, my lord, Department of Supply. And that was civil supply. And that was 100% borne by the government of India, my lord, central government, my lord, not by the state government.
Supplies department is represented. Is it a party here in this proceeding?
no. Not the Union Ministry, because
No, what about the supply, civil supply department?
yes,
Civil supplies.
he's
my lord,
representing, my lord.
My lord, I'm not representing civil
Madam,
supply.
you're
Somebody else.
civil supplies.
Yes.
No,
Standing
my lord.
council is there, Your Lordship, for respondent number 4.
Who was the standing council?
Jamo, Tagum Jamo, Your Lordship.
T. Jamo.
Jamo.
Where is he? Is he around in the court?
My
It's
lord,
not available today. my lord.
since he's not present today.
Can we have tomorrow? We want to pass some orders in his presence so that the
Yes.
matter can be resolved.
Tomorrow or either on Monday or
Monday,
Tuesday.
Monday.
Monday.
But please inform him that is his name reflected in the cause list? Yes, T. Jamo is listed.
No, my lord, just for 1 minute, my lord. They have filed their affidavit, the civil supplies. They have said that no, the bill which was sent, we made an inquiry, and as per us, it is only not 33 lakhs 30,000. It is 5 lakhs 86,070 rupees. Now, that was done arbitrarily. That is another issue. No consultation with anybody, any authorities, but we have accepted in our reply affidavit, we have accepted that, okay, then you pay this at least 5 lakhs 86,070 rupees.
Martin, we can at best decide this matter by directing them to pay the admitted liability, and for the rest you have to approach the civil court.
My lord,
We'll give you the liberty, and
my lord,
this matter is pending since 2022.
22.
We can also make an observation that you take aid of section 14 of the Limitation Act while instituting a municip.
My lord.
I think that order we can pass it right now.
My lord, only one thing, my lord, that's we have taken categorical stand that this amount has to be paid by the central government, not because that is 100% borne by the government of India, my lord. Not, but we don't have a budgetary support for particular this scheme.
Central government is a party here.
No, that is not. We have raised this objection also that since they are necessary part, they have not been made as a party. We have
But
raised.
have you written to the central government?
My lord,
Yes.
Civil supplies?
my lord.
And this figure, 5 lakhs 80,000, is a figure calculated by the central government agencies. Well, they are the implementing agency of this.
Mr. Patil, there would be one small issue. The direction will go to whom?
No, my lord, it is the responsibility of the executing agency here to arrange that is the scheme.
See, that we are aware, we can direct to make the funds ready, but if they have made a categorical stand that the fund is coming from the central government, in absence of a direction to the central government to release the funds, will it serve your purpose?
My lord,
You can dispose of that, it's very easy
yes,
for us.
because it is for them to make arrangement. How they pay, how they make arrangement, that is for them to
Now
decide.
tomorrow they'll say, we have written to the central government, they have not released the funds, then you are in a fix.
Yes, my lord, we have
If a
even
direction was indeed to the central government, they have not released the funds, then you bind them in a contempt petition. That's a different matter.
They can,
Your lordship can, it's
make a
a
party to
matter
the
of,
central government, my lord.
equity, you can slightly, your lordship
No,
can.
no, equity will not make this court pass an order against a party which is not before us. We can mold the relief, we can do something, but entity which is not before us, we cannot direct them to do something. Basic rules of natural justice. But that we can do. I think
But
you
in
can arrange, you can write to the central government.
Yes.
Okay, that much. Okay. Third, three, T party, learned counsel for the petitioner. Also heard. Read T Tagum, learned standing counsel, education department, as well as Miss E Pangu, the learned state council for respond number.
Earlier, Your Lordship, I was for respondent number 4, Your Lordship. Now, standing council.
State council, full stop.
Yes, sir.
State council who has informed that the concerned respond number 4, namely the director, food and civil supply, Government of Arunachal Pradesh, has a standing council, full stop. This court has also noticed that though the name of the standing council is reflected in the cause list, comma, there is no representation. Para. This, considering the facts and circumstances involved, and as agreed to by the learned counsel for the parties, comma, the instant petition is taken up for disposal at the admission stage. Please have your seat. The as per the facts projected, the petitioner firm was appointed as the carriage contractor for lifting and transportation of food grain from FCI Depot Dhemaji to various destinations in the West Siang district in the period 2005-2006. In that regard, a deed of agreement was also signed between the parties. Full stop. The petitioner had also carried rice for sustaining the midday meal scheme. Full stop. The aforesaid scheme was, however, handed over to the Department of Elementary Education in a meeting held on 21/6/2006. Full stop. The petitioner claims to have successfully completed the job for which a bill of rupees 33,68,036 was raised. Full stop. The said bill, however, was not paid, though the petitioner claims the same to be an admitted one. Full stop. Para. 3. Party in the learned counsel for the petitioner has submitted that the work was completed successfully in all respects, and non-payment of the bill in question amounts to illegality and illegality which is also unreasonable. Para. 3. Sagum, the learned standing counsel, Education Department, comma, by referring to the affidavit in opposition filed on 15/7/2024, has however submitted that the work is done through the Civil Supplies Department, namely the respondent of 4. Full stop. He has also submitted that in any event, it is the central government which is responsible for any payment. Full stop. He has also pointed out that in the affidavit, the amount claimed has not been admitted, and the admitted amount constitutes rupees
5,86,070 rupees, my lord.
586,070 rupees. Ms. Pangu, the learned counsel who had earlier appeared for the respondent of 4, has also submitted that the respondent of 4 has filed affidavit in opposition on 29/5/2024 where only the aforesaid amount of rupees 5, comma, so and so, has been admitted. Para 3, Partin, the learned counsel for the petitioner has submitted that even the admitted amount has not been released till now. Para, in view of the aforesaid position, no, don't say right. Read court, while entertaining an application for release of contractual amount, would pass appropriate orders only when such amount is admitted, as a writ court is not a court on facts. Full stop. Moreover, in the present case, there is no admission of the entire amount claimed. Full stop. However, comma, in view of the admission that the petitioner is entitled to rupees 5 so and so, as stated in the affidavit, comma, this court directs the concerned department to arrange for the funds from the central government and ensure that that it is released to the petitioner by an expeditiously,
Time bound.
expeditiously, and preferably within a period of 90 days from today. Full stop. As regards the balance amount, comma, liberty is granted to the petitioner to approach the appropriate civil court for redressal of its grievance. Full stop. The petitioner, if such a recourse is taken, comma, the petitioner will get liberty to take aid of Section 14 of the Limitation Act 1963.
Well, since it is a matter of 2022, 2005, but if this amount is not paid within the reasonable time, and the interest.
You have come to this court after how many years?
16
if you put
years.
this question, your reputation will be dismissed. So you better not raise this question.
Obliged, Lordship.
Obliged, Lordship.
Item number 7.
May I please? Your Lordship, I may be given 2 weeks time to file affidavit in reply to the counter affidavit by the state respondent.
Madam, you have filed counter.
Yes, Your Lordship, we have filed, Your Lordship.
Your IBAM.
Yes, Your Lordship.
Heard 3 IBAM learned counsel for the petitioners. Also heard Ms. P. Pangu learned state counsel and Ms.
Waiga, Lordship.
on behalf of 3 M. Kato learned deputy at GI.
Yes, sir.
Full stop. It appears that the state has filed affidavit in opposition. Full stop. Para 3 BAM, the learned counsel for the petitioners, prays for and is granted 4 weeks time to file rejoinder affidavit. Para list after 4 weeks.
Obliged, Lordship.
Item number 14. Sorry, item number 12.
May I please, Your Lordship, the petitioner challenges the Lordship the legality and validity of the interim suspension order dated 9/3/2024.
Number
12, Your Lordship.
12 was
It was not adjourned, Your Lordship.
16 it was adjourned.
No, 12 was not adjourned, Your Lordship.
It was not adjourned. Only item 8, 9, 8 to 11 was adjourned. Then 13 was adjourned, but 12 was not adjourned.
We have written 16-2. Who made a mention? 16-2? Not adjourned.
Not yet adjourned, Lordship.
Are you sure?
Yes, yes, Lordship.
16-2, maybe it's some other case. Which matter was adjourned to 16-2?
16 to
11.
item
11
11.
was
Yes,
adjourned.
yes, yes.
11.
11 was adjourned.
Mm-hmm. 11 is your case where it got adjourned to 16-2.
Lordship, yes. 11 was.
Okay. Yes, what is this, Mr. Singh?
Lordship, here, the petitioner has challenged the suspension order dated 9/3/2024.
You are in service.
Yes, Your Lordship.
You're
I was
you're put under
suspended.
suspension.
Yes, Your Lordship.
Yes, when was it? Suspended?
On 9/3/2024,
9/3/2024.
I was suspended, Your Lordship. And thereafter, subsequently, extension order of the suspension of the petitioner for another 90 days was extended.
When was it?
On 12/4/24, 8/7/24, 18/10/24.
18/10.
Yes. Then 7/1/25 and on 29/3/2025. Now the issue here, Your Lordship, the extension order, all the suspension or extension was extended during the time period of within 90 days, Lordship. Except to the extent of order dated 18/10/2024. May directly, Lordship, I will take Your Lordship to on 18/10/2024.
Okay.
Which I have annexed at page 54, sorry, page 43, annexure 6, Your Lordship. Kindly see, Your Lordship, on top the
Let's
order.
look on the other side.
Okay.
Yes, Mr. Subu.
Lordship, there's some misconception in the present case here, Lordship. Basically, in deemed suspension, Lordship, and 90 days starts from the day when the release is intimated to the competent authority. But in present case, what happened after he has been released, only, Lordship, the intimation was given. And when intimation was given, but on that very day, Lordship, the suspension order was issued, Lordship.
Because he is not agree. He is agreed with the extension of 18/10/24.
Lordship.
Which was not done within.
I am not raising all these issues.
Initial thing
Yes.
he has abandoned.
Lordship.
But he says that there, though you have the power to extend,
Lordship.
it has to be done within 90 days.
Lordship.
And you have been extending, but 18/10/24 is after expiry of 90 days. Not
Lordship,
within 90 days.
yes, Lordship, one thing, Lordship. If this suspension, therefore there's a misconception where I said so, because intimation was given on 6/9/2024, Lordship. And if 90 days is counted from 6/2024, Lordship, then, Lordship, the next review has to be done before, Lordship, the 5th May 2024, Lordship.
No, that perhaps will be inconsequential. We have already extended on 12/4. 12/4, 8/7.
Past suspension, Lordship. The
First
review,
suspension is 9/3.
9/3, Lordship.
Then 12/4 we have extended.
Yes.
Yes, Lordship.
12/4, then 18/7, 8/7.
Lordship.
Then 18/8, 18/10. Now this 8/7 to 18/10, the period is more than 90 days. That is what is.
That is correct, Lordship. That is correct. But what I am submitting is, Lordship.
No, initial part that will not be relevant.
Lordship.
Now, what is the nature of the charge? First, what is the stage of the proceeding?
No departmental
Proceeding
proceeding,
is-
nothing.
In only criminal cases.
You were arrested in a criminal case.
Lordship.
What case, what charge?
Lordship, corruption charges are there. 468, which I have stated to Lordship.
What post are you holding?
Lordship,
What post?
I'm a personal assistant, PA,
To whom?
to the Director Education, School Education. Under the respondent,
But Mr. Singh, you may have a point of law, but we cannot ignore the facts. You have approached this court when? 2025, with a cause of action which gave you some right in the year 2024, October.
Lordship,
Time has passed. And thereafter.
in the meantime, Your Lordship, I have
Thereafter, review has been done
Done.
on time. Now, you are still under suspension.
Yes, Your Lordship.
What,
I have submitted several representation, Your Lordship.
now, when was the last review order?
Last review order,
Mr. Tapin, you'll be able to say because
Lordship,
Mr. Singh has said 29/3/2025. We are in 2026.
Lordship,
From March to almost a year has passed.
Lordship, that part I have to take.
You take
inspection. Whether it has been reviewed, further reviewed.
If a similar kind of irregularity has happened now recently, then we may interfere, but we'll also give you the liberty to post him in any non-sensitive post. That much, which we have been doing.
Lordship,
See, these are mandatory in nature.
Lordship.
You can place him on the suspension, extend him, but you have to apply your mind whether such extension is required.
Lordship.
And therefore, the aspect of review becomes of significant importance.
Lordship.
Then 90 days is also prescribed. 90 days is not a short time.
Lordship.
3 months you take. Then you apply your mind, yes, whether it's required. And now, in view of the fact that the DP has not been initiated, it is more the
almost 2 years, Lordship.
you apply your mind whether such you may have a good case that he is not required to be in the office till we complete the proceeding
Lordship.
to ensure that there is no tampering or with the records.
Lordship.
And considering the charge, this may be a very good ground, but you have to apply your mind and state it on record, place it before us that yes, on these considerations, we think that his suspension should continue. But that is not happening.
No.
We do not know the present position. We have it on Monday or Tuesday.
Can it be Friday
records-
next or
Not on Friday, on Tuesday, on Wednesday next.
Wednesday?
You just need to bring the latest extension orders. Today is Thursday. You can write it today. You need the latest extension orders, dates. When were those?
Then, Lordship, it may be on Monday, Lordship, because I'm having some difficulty on 10 to 12, Lordship.
Okay, Monday?
Monday,
You can bring it on Monday?
Lordship.
Okay. Mr. Singh,
Lordship on Monday, so right.
heard 3 Singh learned concept for the petitioner who is aggrieved by the continued suspension of which was initiated by an order dated 9/3/2024.
Lordship.
The specific case of the petitioner is that though there has been periodic review, one review done on 18/10/2024 was
Which is backdated, Your Lordship. As per, I have annexed it.
18/10 was beyond the period of
Yes.
90 days. He has also alleged that such extension order was backdated.
Lordship.
This court has, however, noted that in the meantime, more than sufficient time has elapsed, and the latest developments are required to be placed on record, for which this court directs Sri S. Tapin, the learned senior advocate, to obtain necessary instructions. Para, as paid for, matter is adjourned to be listed on Monday.
Monday,
Please
9.
give the date.
9.
Item number 14.
1/4.
Yes.
Who is there? 14?
My Lordship.
Yes.
Lordship, actually, today, the date is fixed for filing of counter affidavit by the respondent, but only respondent number 15 has filed.
Mr. Ratan, where is your counter?
My lord, we would require some more time to file our counter, my lord. That's last order.
Who is 15?
My lord, I'm representing my lord.
Private respondent?
Yes, my lord. I'm a developer, my lord.
Okay. What is your name?
Answer.
I heard 3 and Sahal and concept.
And Lordship, along with this, IS also come up. I have also filed the IA.
IA for?
IA for restraining this respondent from carrying out any construction
When did
activity.
you file?
Yesterday. Now, along with this petition, it's come up.
It has come.
Yes, yes.
IA has been listed today.
Today,
Because they have filed.
yes.
Oh,
Yes,
IA is there. IA
Yes,
39 of.
Yes, yes.
So in the IA, we want you to respond. He is praying for an interim order.
Yes. In fact, the very writ petition, the maintainability was questioned.
Is it?
Yes.
Yes, we also raised, my lord, specifically in our affidavit, my lord, a preliminary objection on maintainability, my lord.
What is the kind of restraint order you are praying for?
Actually, I am praying for limited restraint order. In alternative, I am praying.
What is the kind of restraint order?
Carrying, restraining from carrying out any activity which will cause irreversible damage
What
to
kind
our
of
community land.
What activities?
Land has been
Acquired.
acquired, my lord. We have been, my lord, handed over to the land. We, all the affected landowner has, payment has been made, my lord. Now the land is another possession, my lord. Now it is a public-private partnership, my lord, project for hydro project development, my lord.
Who
Now-
are the petitioners?
They're nothing only short of their land, any properties affected, even in the periphery of the land, my lord. Only their claim is vague, my lord.
You are not the landowners.
Lordship, I will come to that.
No, are you the landowners?
Yes, yes, community land. It's our community land. We are praying under this Scheduled Tribe Act, which is the law governing the law, governing law.
Okay, but who has received the compensation?
The compensation, actually, no one has received. Our land has been made as a forest land by the department. They have shown as a forest land by the virtue of site inspection report, which is the foundation document, Lordship, which is the foundation document basing on.
Challenging something on facts.
Yes.
Can we adjudicate? If you say that your land has been wrongly described as forest land and therefore neither compensation, nothing, and they're trying to utilize, aren't you required to approach the appropriate civil court?
No.
There's a determination on facts.
Lordship, I am not here challenging this. I am not averting this, our title and all. I am only challenging the illegal state action for not complying the procedure which is prescribed under law, which is the Scheduled Tribe and other Forest Developer Act. And there is no compliance. Lordship, my case, let me submit my case. Yes.
What is your position? You are scheduled tribes?
Yes.
Or forest dwellers?
No. Both. This comes under for both Scheduled Tribe and Forest
Who
Dweller.
are you? Are you scheduled tribes or forest dwellers?
Yes, Scheduled Tribe and Forest Dweller.
You're both?
Yes.
You filed a response, Mr. Ratan. Okay.
They are scheduled tribe, but they are not forest dwellers, correct?
No, but scheduled tribes are also protected.
A very narrow interpretation. They are making a very yes.
Scheduled tribe, but the protection is not only scheduled tribe, but they have to be forest dwellers also.
Let us see. Let's see the act.
Yes.
The forest dwellers, other forest dwellers have been defined.
Section 2C, scheduled tribe and forest dwellers.
See the protection, to whom the protection is granted?
Yes. Forest dwelling scheduled tribe means the members or community of scheduled tribes who primarily reside in and who depend on the forest or forest land.
They are not in the forest.
No, my lord.
They are in the villages.
No. Actually, in Arunachal Pradesh, everywhere is forest. Where our at the specific spot, our house is not there.
Mr. Saha, forest dwellers have been defined in that act.
Yes.
You cannot just claim to be forest dwellers because there is some forest. You need to come within that. It has to be certified by the concerned Gambura. Those are the, I think, section 6.
Yes. Those things has not been done. There is no, then who will, my case here is, then if this kind of abutment is there, then who will decide? The decision has to be made by Gram Sabha as provided under this act. So I am saying, where is the Gram Sabha? And there is a notification from Ministry of.
You filed your affidavit.
Yes, madam. There in the coast title, they have themselves described that they are from Sangov 2 village.
Yes.
That it is. It
You
is
filed a response, instead of the IA, we will decide the entire petition.
Yes.
Mr. Tagom has already filed the affidavit.
Yes, ma'am.
And madam, central government, are you required to file anything?
Not just I have not received any instruction.
Is it required, is central government has a role?
My lord, the forest clearance that given by the central government of India, my lord. On everything has been done through
Probably you too will have the major role.
my lord.
And this one, Lordship, in this matter, already this High Court, the protection has been given by this Honorable High Court order dated 15/11/2023, where it has been where it has directed this respondent to set up NIEL and decide this matter. And till then, no deprivation of property should be there. But in violation of that,
Let us give some time. Heard Sri N. Sahar, Learned Counsel for the petitioners. Para. While the respondent number 15.
15, yes.
Represented by Sri T. Tagum has filed the affidavit, comma. The state has not filed, state is yet to file the affidavit. Para. The affidavit of the state would be necessary for a complete adjudication of the matter. Para. On the prayer of Sri Ratan and Ratan, the learned AAG, matter is adjourned. We give a date to 3rd of March or 2nd of March? 2nd of March, by which time the affidavit by the state is required to be filed. Full stop. List along with the IA, filed by the petitioners.
but Lordship, till then, add interim something like that, because that is reverse already forest trees has been cut up. Now, there is locus can be erased, but there is no substance in this.
Any action taken in the meantime shall be subject to outcome of the petition.
The locus and
We will see. Okay. You raise those issues, we will decide.
Orally, locus and all, let them come with filing.
Okay, next.
Item number 15.
My lord, I am appearing for the petitioner.
15.
Yes, my lord.
Madam.
May I, your lordship?
Yes, just a minute.
Okay.
We'll raise this. Raise it a bit. Yes, okay. Yes, Mr. Chaudhary.
Yes,
Yeah,
my
for the
lord.
petitioner.
Yes, my lord. What had happened on 23/9/24, the petitioner was transferred from Teju to Roing. 23/9/24. Pursuant to the order of transfer, I joined on 9/4/25.
May I, your lordship?
Yes.
Here, your lordship, we were supposed to obtain our instruction, your lordship, but we are yet to receive. So at least next week, your lordship.
Is there any interim order?
No, my lord. My humble
No,
submission
your
is
lordship.
I have not handed over charge, nor the reliever has come, my lord. So let them have the instruction. Let the status quo as on today be maintained, my lord.
Yes, what do you say, madam?
Next week, your
Yes, you're
lordship.
for whom?
I'm for the private respondent, Lordship.
You have joined or not?
I have already joined. And
No. If he has joined, then status quo will do. Then he will be safe. If he has joined,
Since last 4 or 5 occasions, there is no status quo, no stay has been given.
No, we are not staying. If you have joined, status quo as on today.
yes.
Lordship, it's amounting to insubordination because he has been already directed to join his posting place at Rupa. He is not going. He is in total subordination. He has been directed by the SC also. There is written direction to go and join his place.
But this notice was issued long time back in 12/2025 transfer matter. Within
Yes.
a week you should
I filed my
get instructions.
I filed my affidavit already.
And madam's affidavit is more.
Yes, lordship.
What are your grounds, Mr. Chaudhary, of challenge?
Yes, ground of challenge is, my lord, within 8 months I have been transferred.
He can find out.
My normal tenure is 2 years, and I have also been transferred on
Yes,
the
23/9/2024, you were transferred from Teju to Roing. You joined on
Roing.
9/4.
Yes, then,
You
my
joined on
lord,
9/4.
yes, I joined. Then, my lord, on
Yes.
6/12/25,
Yes.
that is within a span of 8 months, I have now again transferred to Rupa.
What are the grounds of transfer?
My lord, the order doesn't reveal anything. The ground
Okay,
of
what
challenge,
you were
ground
working
of
as what?
executive engineer, PhD.
And you have been, Mr. Saxena, from?
I'm from Roing to Teju. Or Teju to Roing.
So my learned friend Saxena's client is sought to be brought to my place, my lord. That is at Rowing.
Yes. Lordship,
And
my
now-
only humble, since a lot of time has gone, next week, the matter can be heard and disposed of.
Precisely, that's why status quo.
Can you
status-
get the instructions?
Yes, sir, Lordship.
Monday we'll have this matter for disposal. You
Monday.
get the instructions. Affidavit may not be required, get the records.
Tuesday, Your Lordship.
Tuesday, okay, Tuesday.
Okay, Lordship.
Third, Sri K. N. Chaudhary, London Senior Counsel, appearing online, assisted by Sri N. T. Patil for the petitioner. Para, while the private respondent number 5, represented by Sri Saxena, has filed the affidavit, comma, the state is yet to file the affidavit, full stop. At this stage, comma, Sri Chaudhary, the London Senior Counsel, has submitted that he has not yet handed over charge and accordingly he has prayed for an interim order. Full stop. The same is however resisted by Sri Saxena by stating that his client has taken over charge.
Yes, ex parte.
And the petitioner is not complying with the directions of the department. Para? Be that as it may, comma, list this case for admission hearing on Tuesday next, when an endeavor will be made for disposal of the writ petition, full stop. If such disposal is not possible, comma, this court will consider passing of appropriate interim orders. Mr. Chaudhary, on Tuesday.
Milord, deeply.
Ms. Pangu, the London State Council is directed to have the instructions and along with the relevant records.
Okay. Lordship, apology, there is I am for respondent 4.
Oh, okay. Saxena 4, huh? Okay.
Oblige, Your Lordship.
All right.
Item number 16.
16, yes. Mr. Mao?
Yes, Mala. Mala, in this matter, pleading is complete, so matter can be.
Pleadings are over.
Yes.
What is the matter about?
This matter is about adoption, Mala.
Adoption of
Yes.
what?
Adoption of abandoned child, Mala, who is
Why
with
is the writ petition there?
because child is with fit person. But then
Who are you?
the adoptive mother. In fact, she has been considered as a fit person by the Child Welfare Committee, and
You have been deemed to be a fit person.
fit person. And
What is your
she
grievance?
grievances in this writ petition is that there is a procedure that's called SCARA, which is said that the seniority has to be considered to adopt the child, whereas the child has been with her for almost
Presently, the child is with whom?
with the petitioner for almost 5 years, more than 5 years. So
Yes.
that is this is the
What is
only
there
case.
to be decided now? Last 5 years, petition is pending since 2020.
So it's almost mother and child relations.
There is a bond now.
Yes, that is the issue.
Last 5 years. Are you really contesting this?
Well, there's but
On change circumstances, I don't think there should be any contest on this.
the expert affidavit filed by the respondent number 2 is very on law point.
No, it's point of law, but you cannot ignore the practical aspects. 5 years, what is the age of the child?
Now more than 5 years.
See, from the time of the birth, the child is with the petitioner, adoptive mother. And the matter is pending since the last 6 years.
The only contention is by while adopting all the rules and relevant
No, no, we can make some observation that this will not be a precedent. This will not be a precedent. You have objections in there are reasons for which you had taken this action, but in view of the elapse of considerable length of time and peculiar facts and circumstances, we allow the petition, which will not be a precedent, and it will confine to the facts of the case and not be a precedent. It will be very harsh on the child.
Yes.
After 6 years, if
Yes.
the petition fails for any purpose, if the petition succeeds, nothing like that. If it fails for any technical ground or legal ground, and you have raised very legal issues.
Yes, man. All the legal issue that
Which you may have some point.
Right.
We have seen. And if we are agreeable with you, inclined with you to have an opinion with you, then the future of the child will be in jeopardy.
Yes, that's the issue.
Admittedly, madam, leaving this, madam, the law aspect, madam, we are also, madam, of the view that, madam, this is, madam, the fit to be, madam, considered, madam. Otherwise, madam, at the relevant point of time, madam, the child was, madam, maybe around 2-3
Months.
Months.
only.
Yes. We'll allow this, huh?
Yes.
Then?
Madam, in that case, madam, my confession will head in.
No, we'll definitely, we'll say, and this will not be a precedent.
Yes.
Only on peculiar facts, okay?
Yes.
See, at times, the interest of justice becomes of paramount importance.
Yes, madam.
If you go very technical, it may be difficult. Oh, you are also an MLA?
Yes, present now is a minister.
That has also been pointed out in our affidavit, madam. By taking the advantage of that, madam.
We thought you were
At that time, she was MLA, Your Lordship.
Are you sure there is nothing else in this petition? Once MLA minister comes in, we are slightly hesitant.
But then there is no such misuse of the power, my lord. That was on the basis of the fit person. She was considered.
Oh, okay. Heard 3 censor learned counsel for the petitioner. How many petitioners?
One petitioner.
Only the adoptive mother has come, Mr. Mao.
Yes, my lord.
The Mao for the petitioner. Also heard 3 M. Kato, learned deputy SGI for the
Respondent number 2.
for the deputy SGI, as well as 3 S. Tapin, learned senior advocate Arunachal Pradesh. Full stop. Considering that this matter is pending since the year 2020 and as agreed to by the learned counsel for the parties, the same is taken up for disposal at the admission stage. The facts projected is that on 26/3/2020, a newborn baby girl was found abandoned in the jungle of Paya village in Sunapura circle in the district of Lohit in a critical physical condition and was admitted in the Zonal Hospital Teju. Full stop. The petitioner, on getting the information, had provided for all financial assistance for the treatment of the baby. Full stop. After being treated under intensive care, the baby was released from the hospital and handed over to the Child Welfare Committee, Lohit District. Since the said district lacks specialized adoption agency within bracket SSA, and at that time the country was at a state of lockdown due to COVID-19 pandemic, the District Child Welfare Committee had decided to give the baby to a fit person. Full stop. On such information being received, the petitioner had approached the CWC for custody of the child. The committee had, however, given custody of the child to the sister of the petitioner, for a period of 3 months ending 7/7/2020, so as to inquire the identity of the biological parents of the child. Full stop. However, the I don't say full stop. Since such exercise did not culminate into any result, the child was granted to the petitioner after the period of 3 months, considered by declaring her to be a fit person, vide and order dated 10/7/2020 for a period of 2 months. Full stop. During such custody, a verification was made by the District Child Protection Unit, which culminated in a report dated 31/8/2020, indicating that the child had developed an attachment with the petitioner. Full stop. As the final custody of the child, as the issue regarding grant of final custody of the child was undecided, the petitioner had earlier approached this court by filing WPC 232 (AP 2020), which was disposed of by an order dated 9/9/2020, with a direction to the committee to pass appropriate orders after hearing the petitioner. Full stop. However, on the same day, an order was passed by the protection officer, District Child Protection Unit Teju, for handing over the child. Full stop. Under those circumstances, the present petition has been filed with the following relief. Please quote the relief which is given in page 25. Full stop. Para. 3. Now, the learned counsel for the petitioner has submitted that the petitioner is a fit person and the action of the respondent authorities directing her to hand over the child is without any due application of mind. First of all, he has emphasized that in the meantime, sufficient time has elapsed, and all this time, the child is with the petitioner. First of all, Sri Kato, the learned Deputy SGI, has however submitted that the action taken by the respondent authorities is strictly in accordance with law, and the prayer of the petitioner is not backed by any provision of law. He has submitted that child can be given for adoption only to a fit person, and there are persons above the petitioner in the chronological list. Full stop. Sri S. Tapin, learned Senegal advocate, has defended the impugned action and has endorsed the submission of the learned Deputy SGI. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court, including the relevant statute, have been carefully perused. Full stop. This court is, however, of the opinion, while the petitioner has tried to make out a case for interference with the impugned action, comma, the same has been defended by the learned counsel for the respondents, full stop. Without going into the niceties of the submissions advanced by the learned counsel for the contesting parties, the aspect that in the meantime, more than 6 years have elapsed since the date of handing over the child to the petitioner cannot be overlooked, full stop. After all, it is the welfare and betterment of the child in question which is of paramount importance and also the objective of the statute holding the field, full stop. Para. In view of the above, as an exceptional circumstances, comma, this court is of the opinion that no further action is required to be taken by the authorities for taking back the custody of the child from the petitioner. Full stop. This court clarifies that the present order has been passed in exercise of powers under Article 226 and shall not be treated to be a precedent for any other case. Full stop. The petition accordingly stands allowed in the manner indicated above.
All right.
Item number 17.
My lord, item
We
number,
had 2-3 lines on the closeness and attachment.
item number 17, my lord, as- this is a contempt case, my lord. As per the order dated 15/12/2025, we were asked to file to take steps to respondent number 4, 5, and 6 after the implement, and we have taken step on 11/12/2025. And as per the records, it says that respondent number 4 AD card has received.
Here for 4.
No.
Here for?
Respondent number 2.
Who is for 4? 4 has appeared.
Not yet appeared, but AD card has.
Heard Spree S. Mao, learned counsel for the petitioner. Full stop. As per the order dated 5/12/2025, notice were issued to the newly implemented respondent numbers 4, 5, and 6, which, according to which steps were taken. Full stop. Office note dated 4/2/2026 reflects that the respondent number 4 has been served, whereas the service report upon the respondent numbers 5 and 6 are still awaited. Full stop. In view of the same, comma, matter is adjourned by 3 weeks to enable the respondent number 4 to make representation. Full stop. By the next date, comma, fresh service report upon the respondent numbers 5 and 6 are to be given by the registry.
My lord, we may be allowed to serve through Dusty, my lord.
5 and 6.
5 and 6, yes.
We'll wait for the.
Your Lordship, there has been some recent developments regarding this case. I may be allowed to place those records on additional affidavit.
By the next date, your name?
And Norbu.
And Norbu, learned counsel for respondent number 2 is at liberty to place on record the subsequent developments.
Obliged, Your Honor.
Obliged.
How many more cases?
4 matters, 1 from order, 3 from,
Hearing is there.
yes, 3 from hearing and 1 from.
Will come at 2 o'clock. But we have to rise at 3 o'clock today for reference.
Yes, I came to know.
Okay. Yep.
18.
18.
Yes. Item number 18.
My lord, I am appearing for respondent number 7 and 8. I have not received the copy of the petition.
We have served the copy to the council. Yes, my, so I'll serve the copy.
Nearest.
Yeah, they are the, yes,
Nearest or what?
No.
they are the NHDCL, NSIDCL. NSIDCL.
To the standing, you are the standing counsel.
No, my lord, they have engaged me.
Engaged you, okay.
Because I have been told that there was a council earlier to serve the copy
Well, it's
according.
in the order of 27/1/2026 by which you are given liberty to serve through their
Yes,
council.
accordingly it has been done.
Now he's appearing.
Yes.
you can
No, there is no problem. And only the problem, if your lordship, I'm troubling just your lordship with one order.
Hmm.
If your lordship can look into the order of 9/12/2025.
9/12.
9/12/2025.
Yes,
Just, can I just read this order if it is not inconvenient, my lord?
yes.
So and so, learned senior so and so, who submit a petition are resident of different villages under Tiding region, where they have resided since the time of their forefathers, and they are aggrieved for being excluded from among those to receive compensation for the construction of national highway, particularly in respect to alignment of only so and so.
And there is an order that any constructions in respect of the package, if undertaken, shall be without prejudice
No,
to
no,
rights.
there is another order. The learned government has to obtain update instrument by return on which date interim orders shall be considered. What has happened, my lord? Because my land has been used, but they were not paying compensation. They have used my land, which I am asserting. Secondly, what they are saying, my lord, in full swing the work was going on where there are a lot of jirats. Now I file an additional affidavit before this court. I know, my lord, limitation is these are public important projects. You cannot stall like this. My lord, you cannot stall. But what they can go do it, the government, at least, my lord, a status report can be produced before the court. One. Secondly, my lord, my men can go. Our clan can go along with deputy commissioner, but by that time, these jirats, my lord, a tree cannabon is there. My lord, the oranges are there. If that is destroyed, then nothing will remain. How can I claim, my lord? Land is absolute no problem.
Yadav, how soon can you come back? Yes. You are already requiring agency.
Yes.
Yes.
You are already requiring agency. What is the current position, Mr. Das?
My current position is that the work is going on. The work is full swing, there is going on. Now that is why when the matter was taken up, and these are the latest, we filed an additional affidavit for the court now. And we said these are the works which is going on full swing. I don't want, madam, your lordship will stop this work. At one point of time, it was stopped. It was stopped. Subsequently, again, it continued. Now, I cannot come and claim tomorrow my jirat. Only jirat. Land is, of course, that will be subject to the outcome.
Yes, how do you reconcile this?
Your lordship,
This position which Mr. Das is expressing, that if those are in the meantime destroyed or construction works are done, how do you ascertain later on when there will be nothing?
for that, your lordship, I have to seek instructions, your lordship.
You get up-to-date instruction. What is the present position we want?
Yes, your lordship.
And if it's a vast project, isn't it?
Yes, your lordship.
And apart from the lands of the petitioner, there are other lands also, other properties also. You can go ahead, but petitioner's property without making an assessment. He can be aggrieved by the quantum, or those are different matters. But if you do not make the assessment,
Yes, your lordship.
and you go ahead, then tomorrow it will be impossible for either for him to establish or for you to do a fair assessment.
Yes, your lordship.
Mr. Yadav's clients may not have too much of a say here at this moment.
Yes, your lordship.
Now, the acquisition is done for him.
Yes.
How do you reconcile? You tell us.
Your lordship, I may be allowed some time to seek instructions, your lordship.
Wednesday next?
Yes.
Yes, your lordship.
Wednesday next, Mr. Das? Wednesday
Yes.
next? You can come
11.
on online also.
Yes, yes. If there is difficulty,
Mr. Yadav would like to have your thing on by Wednesday. Is it possible?
I'll just give a copy to him, my lord.
Right now, okay.
My lord, I don't want to.
Maybe limited.
Yes.
If he's not challenging the acquisition per se, then your load may be.
There was no acquisition because it is under 40. They want 40. 40. So 40, your lordship knows, urgent purpose, because there were 3 packages.
Under the 13 Act, 2013 Act.
2013. My lord, they not acquired 2013, but there were 3 packages. Package 1, package 2, package 3. This is in package 3. 1, 2.
That's right. Heard Sri D. Das, Learned Senior Counsel, assisted by Sri I. Das, for the petitioners, pursuant to the order dated 27/1/2026, Sri R.B. Yadav, Learned Counsel, has entered appearance on behalf of the respondent numbers 7 and 8, and accordingly, service upon those respondents are is complete. Full stop.
Yeah.
Sri Yadav prays for some time to respond to the writ petition. Full stop. Para. The London Senior Council has expressed urgency and has referred to the order dated 9/12/2025 of this court. Para. Sri London State Council prays for some time to obtain the updated instructions with regard to the status of the work, which is the subject matter of the acquisition proceeding.
Yeah. They have not started also initiated. Okay.
List for consideration on Wednesday next.
Yes.
Obliged, Your Lordship.
You can hand this on Wednesday.
It is on 11th, I think. 11.
11.
If possible, I'll come. Otherwise, I'll be online.
Okay.
I'll do online.
No problem.
Obliged, Your Lordship.
Mr. Das, collect these copies.
Deeply obliged.
Item number 19.
Hearing.
Yes.
Yes, ma'am.
Hearing.
You come to your matter.
Yes, my lord.
Yes, yes.
My lord, let me highlight the facts, my lord. Petitioner, my lord, she has a plot of land, my lord,
Yes.
measuring,
Who's for the other side?
Yes, I'm for private respondent number 3 and 4.
You're for the government.
two 216 square meters, my lord.
Hmm?
At petitioner, she has a land, my lord. Against which
You have
he has
plot of land,
obtained his,
you have-
this
you have
LPC.
plot of land.
Yes, my lord.
Hmm.
Measuring 216 square meters only, my lord.
Yes.
And she has been issued LPC against that particular land, my lord.
Yes.
And my lord, what happened in the year 2014, my lord, petitioner, she was landed in this financial trouble, my lord. Therefore, on being approached by the respondent number 3, my lord, private respondent number 3, that on the agreement that, my lord, as my lord, the petitioner, he was
Mr. Gyati, you're for the R3.
Yes.
3 and 4, my
3
lord.
and 4.
3 and
Private
4.
respondent.
Yes, ma'am. So she owed some money to several individuals, my lord, from where she has obtained this loan, my lord. And since he was unable to pay it back, my lord,
Okay.
so therefore, on being approached by respondent number 3, that on her behalf, he will liquidate all the loans, my lord, liabilities that the petitioner owed to us several individuals.
Yes.
So therefore, on that verbal agreement,
Yes.
she signed a, my lord, purported gift deed, my lord,
Regarding
regarding that land, my lord.
land, he will be given to him.
Yes, my lord.
And he will take care of all the liability.
Yes, my lord. That was the agreement, my lord. Thereafter, my lord, what happened? Since that was the agreement, my lord.
Yes.
So when he did not pay the liability, my lord, on behalf of the petitioner.
R3 did not pay.
Yes, yes, my lord. Then I had lodged a complaint before the deputy commissioner, my lord.
Yes.
Not only was, my lord, several complaints were lodged for revocation of that gift deed, my lord. Owing to which, my lord, finally deputy commissioner, I shall, my lord, marked the matter to EAC, my lord, Naharlagan, my lord, as the subject matter was within his jurisdiction.
Yes.
So therefore, EAC has issued order for conducting mail, my lord, Keba.
Oh.
On 3 occasions, my lord, Keba was conducted. In first occasion, my lord, private respondent number 3 did not turn up. So therefore, a next date was fixed.
Yes.
My lord, this precisely tell this
applies the date of the mail also, my lord. But I am just highlighting the fact right now.
Yes, yes.
On 3 occasions, my lord, this mail was conducted. On the first occasion, private respondent number 3 remained absent.
Mm.
On the second occasion, my lord,
Yes.
both the petitioner and private respondent, they participated. They appeared before the mail.
Yes.
But since there were some witnesses, my lord,
Yes.
who were to be examined,
Yes.
they did not turn up in that this Keba.
Yes.
So, therefore, for doing this full justice, the male members thought that, my lord, at least evidence has to be taken. So, therefore, on that day, on the second Keba itself, my lord, when both the parties were present, private respondent, he had agreed that he could not perform his part of duty.
Yes.
And thereafter, since there was no evidence appear on the second occasion, so the male member thought that for achieving this full justice, witness has to be, my lord, examined. So next date was fixed.
Third date.
Third date.
Okay.
Thereafter, on the third date fixed, my lord, the private respondent remained absent.
Mm.
But since there was admission in the second date, my lord, when the matter was fixed for hearing, there was admission by the private respondent number 3 that he could not able to perform his duty,
Yes.
part of duty. That was regarding this liquidation of the loan on behalf of the petitioner. So therefore, basing on his admission, Keba was conducted, and it was held that in the decision of the Keba, it was held that since there is an admission by the private respondent himself, so therefore, the land will revert back to the petitioner.
Yes.
And in the meantime, my lord,
Yes.
while the Keba was conducted, in the meantime, he has already obtained LPC, my lord.
Who? The
Respondent number 3. So therefore, on the basis of Keba decision, which is submitted to the Deputy Commissioner, the Deputy Commissioner, he cancelled the LPC issued to the private respondent number 3. Yes, my lord. Thereafter, my lord, when the
Yes.
when his LPC was cancelled, he has moved this honorable court by filing writ petition, my lord. That writ petition, my lord, is also annexed, my lord. In that writ petition number, my lord,
132/2018. 132/2018.
Yes.
Yes, ma'am. In the writ petition, since his contention in the writ petition was that while cancelling his LPC, he was not heard. He was not given the opportunity, my lord.
Okay. Then
That writ petition was disposed of, my lord, by order, my lord, 8/4/2022, my lord. That is, my lord, annexed in page number, my lord, 54. 54, my lord. My lord, may kindly come to page number 54. I will just, my lord, read the relevant, my lord, para, my lord. Concluding para is at page number 65, my lord. Para 60, my lord. In the result, I find sufficient merit in this petition. Accordingly, the petition stands allowed in part. The imping order of Deputy Commissioner, Itanagar Capital Complex, Itanagar dated so and so, stands set aside and quashed, as the same was passed without affording an opportunity of being heard to the petitioner, and by which the principle of natural justice stands violated. It is provided that the Deputy Commissioner, Itanagar Capital Complex, Itanagar will hear the matter of cancellation afresh by affording an opportunity of being heard to the petitioner and thereafter to take a fresh decision upon the same. The above exercise has to be carried out within a period of 1 month from the date of receipt of certified copy of this judgment and order. The petitioner is directed to obtain a certified copy of this judgment and order and to place the same before the Deputy Commissioner, Itanagar Capital Complex, Itanagar. However, I find that the impugn cover decisions requires no interference of this court, and accordingly, the same stands affirmed. So, my lord, that decision as I have submitted, my lord, that was with regard to non-payment of the agreed amount on behalf of the petitioner. And therefore, since he could not perform his part of duty, the land was restored to me. That gift was cancelled by the mail. So that was the Keba decision, my lord. So on that, on the basis of that Keba decision, his LPC was cancelled. Against that, my lord, he has filed this writ petition, and this was the judgment, my lord, passed by this honorable court. Now, what happened, my lord? After that, my lord, after that, the Deputy Commissioner, my lord, has, my lord, cancelled my LPC, my lord, and thereby restoring his LPC that was cancelled by the Deputy Commissioner. So against that, my lord.
Now your LPC has been cancelled.
Yes, my lord. And LPC issued in his paper has been restored, my lord.
Which date?
My lord, by order, my lord, 36/2022, my lord. This is passed that order, my lord. That order, my lord, impugn order is at page number 66, my lord, annexure 6. Sorry, annexure 12. This order has been, my lord, impugned in this writ petition, my lord. The petitioner Lolang Baga is not present, my lord. The order says, my lord. Page number 66, my lord.
65.
66, my lord.
66.
Yes, my lord. Annexure 2. This order is now being, my lord, impugned in this writ petition, my lord. Petitioner Sri Lolang Baga is present before the court. However, he is represented by Lord Counsel Sri J.B.R. Gate. Respondent Srimati Techimania present along with her Lord Counsel so and so. Today, the case is fixed for submission of document by the respondent Srimati Techimania in support of her claim. Heard the Lord Counsel of both the parties. Upon hearing this court, finds that there is no any supporting document in support of the claim of the respondent Srimati Techimania. She has failed to submit any document with any agreement, promissory note. Neither there is any record that proves that the gift deed executed between the party has been revoked. In view of the above, this court deems think fit not to cancel the land possession certificate issued in respect of Sri Lolang Bagang by number so and so for the land measuring 216 square meter at Model Village, Nahalnagar. Hence, the land possession certificate in respect of Sri Lolang Bagang shall maintain the same. The aggrieved party is at liberty to approach before the competent civil court for the end of justice. On the above direction, the matter is disposed of. Inform all concerned to the present accordingly. Now, my lord, my contention in this writ petition, my lord. This order, my lord, in fact, while the hearing was being taken up, my lord, by the Deputy Commissioner, petitioner has placed so many documents before the Deputy Commissioner, my lord. That document is, my lord, first of all, the mail decision, my lord. by which,
Your impugned order is at page 66.
yes, my lord. It says, my lord, for a moment, my lord, just assume, my lord, petitioner, my lord, she has so many documents in his paper with regard to this particular land. Firstly, my lord, while the agreement was made, gift deed was made, this Bagang, the name is also given in my writ petition, who was then serving as the circle officer at Bandardua, who is the brother of Lolang Bagang, the respondent number 3. He stood as the surety of respondent number 3.
Surety in where?
Sir, guarantor.
Where, in which case?
In the event that if he could not make the payment.
Oh, in that original.
Yes, in that he could not make the payment on behalf of the petitioner, then the liability will be shifted to him, the brother.
Brother is what?
That brother, he is CO, my lord. He was then CO.
Circle officer.
Circle officer. Serving as circle officer at Bandardua, my lord. Pama Bagang, name is Pama Bagang, my lord. My lord, may kindly come to page number 9, my lord. I'm sorry, my lord. Yes, my lord. My lord, may kindly come to page number 53. This is the application, my lord, submitted to the Deputy Commissioner by Pama Bagang, who was then CEO, who is also a brother of respondent number 3, my lord.
50?
53, my lord. 53.
CEO. He's the brother of Ward 3.
Yes, my lord. My lord, may I read, my lord? Address to the Commissioner. Subject, clarification with a request for issuance and restoration of LPC issued by number so and so to Techimania against her land situated at Model Village, Nahalgan. With due respect and humble submission, I beg to state that a land measuring 216 square meters situated at Model Village, Nahalgan, against which aforementioned LPC was issued to Srimati Techimania. One day at my circle office, officer, CO office, Techimania entered a sale deed agreement with 1-3 Lolang Bagang on my assurance that I shall stand as surety grantor for Lolang Bagang in the event of...
Lolang is R3.
R3, yes, my lord. In the event of failure of Mr. Lolang Bagang to pay the agreed amount of rupees 60 lakhs, that was to be paid by Lolang Bagang to several individuals, my lord, from whom I have this obtained loan, my lord. Out of which an amount rupees 15 lakhs to Lucy Techi, rupees 6 lakhs to Kochi Bagang, and rupees 3,50,000 to Srimati Sengte Bagang. That it is to inform you that despite my repeated approach, Lolang Bagang had not paid any amount, neither to those above mentioned person nor to Srimati Techimania and as such, I subsequently told Techimania that I shall be no more guarantor of Lolang Bagang. When I asked Techimania to take back the gift deed and sell the document, Lolang Bagang repeatedly made pretext of its being lost, whereas it was later on come to know that the same was further given to Kumar Raja. It was further told to Techimania to take back her land from Lolang Bagang. It is pertinent to mention here that Srimati Techimania and other witness of the deed of agreement that so had put their respective signatures only on my personal insistence and assurance to liquidate the amount on behalf of Lolang Bagang. Now, since neither Lolang Bagang nor I had paid the agreed cost of the land to Techimania, therefore the same land may be restored to Techimania by restoring her LPC mentioned above. Therefore, I request you to kindly restore the same land to Techimania by denouncing other LPC that may have been issued against the same land to Lolang Bagang or any one claim through him. So this was.
This letter is in your favor.
Yes, my lord. And Deputy Commissioner, while passing the impugn order, my lord, says that I could not place any document, my lord. Since already at the time of hearing, my lord, date of hearing, my lord, I have all these documents with me, my lord. It is beyond imagination, my lord. A person who is having a document, my lord, in his favor, will, my lord, will he be, not, my lord, place the document before the authority, my lord? It is even unimaginable, my lord. So this impugn order, my lord, that has been passed, my lord, in connivance with the artery. Now, this is one of the documents, my lord, I have in my favor. And other document, my lord, I have. And mail decision, my lord. Let us come to mail decision again, my lord.
Just 7, page number 45.
Annexure 7.
Yes, Government Council.
45.
Yes.
Mr. Kamduk?
My lord.
Government Council.
Government, my lord, he was here. He's coming. He's coming. Yes.
He's making an assertion that page 66, the impugned order.
Yes, Your Lordship.
Dated 36/20/22 has recorded a finding.
Yes, Your Lordship.
That the petitioner, that the respondent, the present petitioner was the respondent in the proceeding.
Yes, Your Lordship.
Where Mr. Gyati's client was the petitioner. That there was no supporting document in support of the claim of the respondent, Techimania.
Yes, Your Lordship.
That is the principal ground of passing the order.
Yes, Your Lordship.
See, contentious issues. And DC was adjudicating this matter and which culminated with this order of 2022. Is it conceivable that contesting parties will not produce any documents?
Your Lordship, it was with regard to the revocation of gift deed, Your Lordship. It was only on the basis of that this order was passed, Your Lordship.
No, she has failed to submit any documents, any agreement, promissory note. Neither there is any record that proves the gift deed agreement will have been revoked.
Yes, Your Lordship.
That is one part.
Yes, Your
First part. And why so? Because Mr. Kamduk is also relying upon a letter of 2015 allegedly written by the brother of the respondent number 3, supporting the present petitioner.
Yes, Your Lordship. As per our affidavit, Your Lordship, we are only on to the point of this revocation of gift deed, Your Lordship. In that context only, we have issued this order, Your Lordship.
See, let us understand the case properly.
Yes, Your Lordship.
We'll hear you, Mr. Gyati.
Yes,
see, he had some liabilities,
yes,
financial liabilities.
Yes, Your Lordship.
Mr. Gyati said that I will take care of your liability in lieu of the land.
This is disputed.
And that is his version. We'll say. We'll hear it. Then a gift deed was made in favor of Mr. Gyati,
yes,
but he did not discharge his part of the obligation of returning the money. Correct? So he made a complaint for revocation of the gift deed.
Yes, Your Lordship.
The DC wrote to the EAC Naharlagun. EAC directed the KEBA to conduct a proceeding.
Yes,
3 dates were there. There may be some disputes, but ultimately petitioner says that Mr. Gyati had, on the second date, he made some concessions. But on the third date, he was not present. On the third date, the KEBA had passed a decision that land has to revert back to the petitioner.
Yes, Your Lordship.
And in the meantime, Mr. Gyati's client had obtained the LPC. So, as per the KEBA decision, LPC was cancelled in favor of the present respondent number 3. That was the subject matter of the
earlier writ petition.
Earlier writ petition, there is a very interesting twist here. Why the writ petition was allowed it was allowed mainly on the point of violation of principles of natural justice,
Yes, Your Lordship.
qua the action of cancellation of the LPC.
Yes, Your Lordship.
Court has not said anything of the KEBA. Rather, the court has said that KEBA decision is affirmed.
Yes, Your Lordship.
Now that decision of the Honorable Single Judge is not challenged anywhere else,
Yes,
in
Your
any higher forum.
Yes, Your Lordship.
So that has attained finality.
Yes.
Honorable Single Judge Justice Fukan has said that if you read the judgment at page 54, 55, come to the last,
65, Your Lordship.
you're right, 65. At 65. However, I find that the impugned KEBA decision require no interference.
Yes, Your Lordship.
That means the KEBA holding that the land is required to be reverted back to the petitioner.
Yes, Your Lordship.
There was no interference with that.
Yes, Your Lordship.
That has attained finality.
Yes, Your Lordship.
In that context, how the present impugned order will be allowed to stand?
Yeah. Basically, the issuance of this impugned order, Your Lordship, it was based upon there is no revocation of the gift deed that was earlier executed, Your Lordship, between the petitioner and the private reservation number 3, Your
Now,
Lordship.
if the High Court has affirmed the action of the KEBA
Yes,
in
Your
directing handing over the land to the petitioner,
Yes, Your
which has attained finality,
Yes, Your Lordship.
thereafter, is there any scope to pass such an order?
In that way, no, Your Lordship.
High Court order is there.
Yes, Your Lordship. In my humble.
Even if we go what has been written in the order 36/2022, this order has been passed consequent upon a remand order by the High Court,
Yes, Your Lordship.
right?
Yes, Your Lordship.
High Court had said that the principles of natural justice are not followed. Correct? And the matter was remanded at page 65.
Yes, Your Lordship.
On remand, this order has been passed. That means, at least if no other documents, the DC was aware about the High Court's order, including the finding and the penultimate paragraph. Yes, Mr. Gyati, difficult case for you. Why haven't you challenged the High Court's order?
I'm put a respondent.
Understood. But your petition earlier,
Yes.
you had a petitioner in the earlier case.
Yes.
It was allowed only on the issue that principles of natural justice was violated
Yes.
before cancellation of your LPC.
Yes.
But at the same time, the High Court had made an observation that no infirmity was noted with regard to the KEBA decision.
Yes, that is there. And as well as High Court have directed both of us to approach the Deputy Commissioner within 1 month so that Deputy Commissioner can ascertain.
Yes.
On that basis,
No,
we
no,
have
but
approached.
what about this confirmation? There is no the at page 65.
Yes.
However, and both the parties were not given. So just see, let us read the entire paragraph 16 again, page 65. Please read
Yes.
in the result.
However,
In the result, 16.
in 16,
Yes.
in the result, I find sufficient merit in this petition.
This petition means your petition. Yes, accordingly.
Accordingly, the petition stand allowed in part. The impugned order of the Deputy Commissioner, Itanagar Capital Complex, Itanagar, dated so and so by so and so, stand set aside and quash. As the same was passed without
Affording an opportunity of being heard.
to the petitioner, to me.
Yes. Yes.
And by which the principle of natural justice stand violated. It is provided that the Deputy Commissioner, Itanagar Capital Complex, Itanagar will heard the matter of cancellation afresh by affording an opportunity of being heard to the petitioner and thereafter to take a fresh decision upon the same. Only on this basis, again, I have approached the learned Deputy Commissioner.
Yes.
By supplying this honorable court's order.
Yes. Please read again.
The above exercise has to be carried out within a period of 1 month from the date of receipt of a certified copy of this judgment and order. The petitioner is directed to obtain a certified copy of this judgment and order and to place the same before the Deputy Commissioner, Itanagar Capital Complex, Itanagar. However, I find that the impugned KEBA decision requires no interference of this court and accordingly the
Same stands affirmed.
affirmed.
Keba has been affirmed.
In Keva, there were two issues. There were two issues. Monetary and then the land.
Let us see the Keba decision.
Yes, my lord.
Page.
This, my lord. Page number 45 to 50, my lord. Page 45, my lord.
Certain pegs still, my friend, is to be disclosed. Certain pegs. Still, there are certain pegs behind this case.
Let us see the last decision. Keba decision.
My lord.
Page.
My lord.
47. Is it 47?
Page number 40. It starts from page number 45.
45. Okay.
Yes, my lord. And my lord, this will be important, my lord. Whole this Keba decision has to be read, my lord, to understand the context, my lord. May I read, my lord? As per the ESC order.
This is the decision. Date.
Decision date is my lord. 10/11/2015. No, sorry, my lord. 10/11/2015.
Yes, please read.
My lord, as per the ESC order number so and so, dated 3/11/2015, all the male members gathered at Male Ghar, Nahalgan today to settle the land dispute case between Srimati Techimania and Lolang Baga, and anyone claim the same land situated at Model Village, Nahalgan to Lolang Baga. This mail is being conducted for third time today on 10/11/2015. Earlier in two occasions, the ESC Nahalgan has issued order twice summoning both the parties to attend the mail on 16/10/2015 and 3/11/2015 respectively. But the same could not be held because in the first occasion, some important witnesses remained absent. And in the second occasion, that is on 3/11/2015, the mail could not be held due to the absence of Lolang Baga. Today, the mail speaks for the third time. Srimati Techimania and her witnesses are present. We have waited for Lolang Bagang for a long time, but he had not turned up despite the knowledge and notice about today's mail. We therefore deem it proper to hear the matter ex parte and more so on 16 October 2015. Mr. Lolang Baga has stated before us that since he could not perform his part of the agreement, whereby he has agreed to pay rupees so and so and rupees so and so to Srimati Benge Bage, he do not any right over the said land. Accordingly, the male members allowed all the Techimania and other witnesses to depose their statement after preparing the following issues. Who is the owner of disputed land at Model Village? Whether Techimania entered agreement with Lolang Bagan? What was the terms and condition of the agreement? Whether the terms and condition of the agreement was performed by the parties? Whether Techimania executed any...
Yes, we have read this.
Yes,
Mr. Jati, this decision of the Keba of 10/11/15 has been affirmed by the High Court.
In the same time, High Court has been...
High Court only interfered with the decision of the Deputy Commissioner regarding cancellation of the LPC.
Yes, and thereafter High Court has again directed us to hear the press.
Yes, only for the LPC purpose.
And accordingly, Lordship, thereafter Deputy Commissioner, what his order in the last, kindly see the page 66, last sentence.
Yes.
The Deputy Commissioner, I'm not, as the petitioner C has submitted, that C has produced many documents, but that has not been considered. That is, the Deputy Commissioner stand is as on today also. Not a single document was produced. In the affidavit also, Deputy Commissioner, it is clearly they have submitted. Now Lordship, the aggrieved party is at liberty to approach before the competent civil court for end of justice. After this order, Deputy Commissioner have directed both the parties, if any aggrieved. Since the Deputy Commissioner have no any jurisdiction to trial the land disputed, therefore, Deputy Commissioner have given liberty to approach the civil court. Accordingly, the petitioner C has approached the learned civil senior division at UP.
Is it?
Yes. After few trials, again C has withdrawn on the condition that she have got some new documents and she need to file that document in that her plan. Therefore, she withdrew the petition with liberty to file fresh. And in the meantime, she didn't file the title suit. She has approached this honorable court. This is the fact of the case. This order is the civil court's order. I have NS in my affidavit also. And thereafter, Lordship, what happened? After my filing the affidavit in opposition, the petitioner, again she filed rejoinder against my affidavit in opposition. May Lord, her rejoinder, very ironically, her statement is contradicted in the rejoinder. Lordship, in her rejoinder, what she said that she has procured new document and accordingly she has approached the sub-register. The sub-register who maintained the record, all the documents, say for example, gift deed or any official document, the sub-register used to make a record. They have approached because the confident who can cancel the gift deed is the sub-register, because this gift deed has been executed between by the petitioner and the respondent number 3. We have registered before the sub-register.
Yes.
Then, if anyone to cancel, then he had to approach the sub-register. On that basis, already I have, basis of the gift deed, I've already procured the LPC. And one more fact is that after getting the LPC, again I have gift deeded to the respondent number 4. Respondent number 4. Of course, respondent number 4, he didn't procure the LPC. This is the fact. Now they have filed rejoinder stating that this honorable, kindly take to the page, their rejoinder. Very categorically they have said, petitioner's rejoinder, page 40. Page 40. This is the petitioner's rejoinder. Page 40. Page 40.
Yes.
From the top, 1, 2, 3, 4. Fourth line, the Honorable High Court.
Yes.
This is their rejoinder. The Honorable High Court has no jurisdiction to entertain the matter in respect of cancellation and revocation of any gift deed, and it is the sub-register who is the competent authority to entertain the registration, cancellation, and revocation of the gift deed. And since the aforesaid gift deed was registered before your good office, and as such, this instant application has filed before this court for cancellation and revocation of gift deed dated so and so executed between Sri Lolang Bagang and me on the following ground. This application they have filed before the sub-register. As on today, this has not been disposed of. And sub-register is the confident authority who can cancel the gift deed. And thereafter cancelling the gift deed only, my LPC can be cancelled. This is the procedure, Lordship. Because on the basis of gift deed, I have procured the LPC. Therefore, Deputy Commissioner rightly directed that if any, because many documents has been disputed, as the petitioner has said that I have verbally agreed to pay back his due 60 lakhs. Lordship, it cannot be believed. 60 lakhs, this is not a small amount. How I can agree verbally? If really it's so, it could have been in written form. Therefore, there are many documents are disputed. Therefore, my humble submission, Lordship, before wasting this honorable court precious time, this case may be referred back to the trial court. There are certain things which has to be need trial. For the
But where will the findings of the KIBA go? The findings of the KIBA, which has been affirmed, which have been affirmed by the High Court.
That is there, Lordship.
Where will it go?
It's Lordship.
Do you say that KIBA is not competent to decide the issue?
No.
Based on the findings, KIBA gives the recommendation.
Only I have challenged the KIBA for not giving me the opportunity of. Oh, no, I'm not challenging the KIBA.
KIBA is not
Deputy
there.
Commissioner's
Deputy
cancellation.
Commissioner, yes, LPC.
Yes. So there are many things which needs the trial, Lordship. For both parties. Therefore, initially they approached the civil court. For what reason, I don't know. Again,
No, you may be right in contending that civil court was approached, then withdrawn, and he has come to the High Court. But at the end of the day, we have to go back to the judgment passed by this court where the Keba decision was affirmed.
Lordship,
After the High Court has affirmed a Keba decision holding the give deed to be illegal, where is how can you again contend?
My Lordship, my understanding is that
The High Court has approved, given the seal of approval. You may be technically right in contending that the cancellation has to be done from the office of the sub-registrar. It can be in terms of a decree of the civil court or by a High Court's order. But Keba decision has been upheld.
in the meantime, this Honorable Court directed, accordingly, I approached the learned Deputy Commissioner. On the basis of the direction of this Honorable Court only, I have approached. And Honorable learned Deputy Commissioner also very fairly, because he has no any jurisdiction, any aggrieved party may approach the trial court, civil court. Accordingly, she approached.
No,
at that point of time,
that development would be material, but that cannot be a reason to preclude him from challenging the decision of the Deputy Commissioner in a writ proceeding, which he has done subsequently, this proceeding, present proceeding. We are required to answer this case.
To my understanding, Lordship, petitioner she ought to challenge the WPC, that previous WPC.
Which one?
WPC.
Challenge what?
Because there were contradict judgment, because this Honorable Court has directed me to approach the learned Deputy Commissioner.
High Court, the High Court in the first round has come to a finding that the cancellation was done, the recommendation was, the cancellation of the LPC was done without giving you any opportunity. It is only on that ground of violation of principles of natural justice that the matter has been remanded.
Yes, and to take press decision.
Yes, but the decision of the Keba has been affirmed. Not only not touched, but affirmed.
But also directed to take a press decision. High Court has been directed.
Decision taken by the Deputy Commissioner.
Yes, directed.
By giving an opportunity.
Therefore, after.
Where is the requirement for the Deputy Commissioner to again take his views?
Deputy Commissioner also, on the basis of order of this Honorable Court only, he has taken the press decision.
Press decision could not have been taken in this manner. By taking into the aspect of he is not being able to give any documents. It was only with respect to the cancellation, subject was cancellation of your LPC, whether it could be done or not. In view of the Keba decision affirmed by the High Court, he doesn't need any other document. Is there any requirement? Just tell us. Deputy Commissioner is examining the aspect of cancellation of your LPC. He came to the High Court.
Yes.
It was cancelled. You came to the High Court, said that I was not given opportunity. Deputy Commissioner will give an opportunity. At the same time, Deputy Commissioner cannot ignore the remand order of the High Court, which has affirmed the Keba decision. Difficult.
I acknowledge.
You should have challenged this High Court's second part. First part, you are okay. But you could have very well challenged that if this observation is there, how will it materially affect the decision of the Deputy Commissioner? Now, earlier he has not heard you, now he'll hear you and pass the same decision because Keba decision has been upheld. If the Keba decision was not touched or no observation made, matter would have been slightly different. But here, High Court has gone one step ahead. So far as Keba decision is concerned, we do not form any infirmity and rather we affirm the decision. Matter ends there.
Ask me to approach the Deputy Commissioner also in the last parad.
Only for the principles of natural justice.
Yes. Oh, that what I have done.
That will end only in one result. Give an opportunity, maintain the cancellation. But Deputy Commissioner had gone on a different footing, asking the petitioner presently for documents. He was not required. Okay. Any other case?
Yeah, two matters are there in here. Yeah, two matters are there.
More hearing is there. Perhaps we will dictate this now. Other hearings cannot be, we'll have to rise also. Because of the reference, please write, we'll dictate the judgment now. The approach to this writ court under Article 226 of the Constitution of India has been made with the following prayer. Please extract the prayer at page 18-19, okay? As per the facts projected, the petitioner is the owner of a plot of land measuring 260 square meters, for which necessary land possession certificate written by LPC was issued in her favor.
216, 216.
216, okay.
Yes.
Not 260. 216, not 216. 260, 216, okay. Sometime in the year 2014, the petitioner was in financial difficulties, and in that situation, the respondent 3 had offered for liquidating all the liabilities of the petitioner, in lieu of which the land was to be gifted to him. Full stop. Accordingly, an agreement was signed. Full stop. However, it is the case of the petitioner that the respondent.
Sorry for interrupting. Not agreement, oral agreement.
You said agreement was signed, you said.
It was signed.
That is his projection.
Yes.
Agreement was signed. However, the respondent 3 did not discharge the liabilities for which the petitioner had lodged a complaint for revocation of the gift deed. Full stop. The deputy commissioner, which district? Capital Complex.
Yes,
Had accordingly directed the EAC Naharlagun to take necessary steps, pursuant to which the EAC had directed the KEBA to be conducted to look into the matter.
Yes.
Full stop. It has been contended that on 3 occasions the KEBA was convened. Full stop. On the first occasion, the respondent 3 was absent, and on the second occasion, both the parties were present. Full stop. However, the witnesses did not appear. Full stop. It is the case of the petitioner that in the second occasion, the respondent 3 had conceded that he could not discharge his obligation. Full stop. Be that as it may, the KEBA was convened on the third occasion when the respondent 3 was absent. Full stop. However, based on the concession made by the respondent 3 in the second occasion, the KEBA had taken a decision that the land would have to be reverted back to the petitioner. Full stop. Pursuant to the aforesaid decision, the deputy commissioner had cancelled the land possession certificate which the respondent 3 had in the meantime obtained. Full stop. The aforesaid decision of cancellation of the LPC was the subject matter of challenge in a writ petition instituted by the respondent 3, being WPC 132 of 2018. Full stop. The primary ground of challenge was violation of the principles of natural justice, as the respondent 3 was not given a proper opportunity to present his case. Full stop. Para. This court, while order dated 8/4/2022, had allowed the writ petition and remanded the matter for a fresh consideration only on the ground of violation of the principles of natural justice. Full stop. However, this court had made an observation that the decision of the KEBA was not interfered with, and rather the same was affirmed. Full stop. On such remand, the Deputy Commissioner has passed an order dated 36/2022, whereby the LPC in the name of the respondent 3 has been restored. Full stop. It has been observed in the impugned order that the present petitioner could not produce any documents. Full stop. Liberty was, however, granted to the parties to approach the appropriate civil court. Full stop. It is the aforesaid order which is the subject matter of the present challenge. Full stop. Para. I have heard Sri so all the names. Para. Sri Kamruk, the learned counsel for the petitioner, has submitted that the findings made by the Deputy Commissioner that no documents could be furnished by the petitioner is palpably incorrect, inasmuch as such observation cannot be conceived in a contentious matter of this nature. Full stop. He has also drawn the attention of this court to a communication dated 2011-2015 issued by the brother of the respondent 3, who was the circle officer. Full stop. In the said letter, it has been categorically stated that the brother who was a guarantor would no longer stand as a guarantor, as the respondent 3 had failed to discharge his obligation as per the agreement. Full stop. Para. The learned counsel accordingly submits that the impugned communication dated 36/2022 is liable to be interfered with. Para. For contra, Sri Sriram, the learned state counsel, has submitted that this court, via the order dated 8/4/2022, had remanded the matter to the Deputy Commissioner, who had considered the matter and passed the impugned order in accordance with law. Full stop. Para. Sri Gyati, the learned counsel for the respondent 3, has strenuously opposed the writ petition. Full stop. By referring to the affidavit in opposition filed by his clients and also the rejoinder thereof by the petitioner, he has submitted that pursuant to the observations made in the impugned order dated 36/2022, the petitioner had in fact approached the civil court, which, however, was withdrawn on the ground of submitting more documents, and thereafter the present writ petition has been filed. Full stop. He has also drawn the attention of this court to the application filed by the petitioner before the competent sub-registrar for cancellation of the gift deed, which is pending, and the same is enclosed to the affidavit in reply filed by him. Full stop. He has also submitted that disputed questions of fact are involved, which may not be gone into by this court in exercise of its rich jurisdiction, and the petitioner, if aggrieved, can approach the competent civil court. Full stop. Para. The rival contentions have been duly considered, and the materials placed before this court have been carefully examined. Para. Before going to the issue which requires adjudication with regard to the legality or otherwise of the order dated 36/2022 passed by the Deputy Commissioner, it would be required to take into consideration certain important background facts, including the observations made by this court in the earlier round of litigation, being WPC 132 of 2018. As stated above, the aforesaid writ petition WPC 132 of 2018 was instituted by the present respondent number 3 with regard to cancellation of his LPC in terms of the KEBA decision dated 10/11/2015. Full stop. This court, vide judgment and order dated 8/4/2022, had interfered with such cancellation, which however appears to be only on the ground of violation of the principles of natural justice. Full stop. This court, however, had made a very important observation that the decision of the KEBA was not interfered with, and rather the same was affirmed. Full stop. For ready reference, the said observations made in paragraph 16 of the judgment dated 36/2022 are extracted herein below, page 65, paragraph 16. Full stop. It is not in dispute that the observations were not put to further challenge and have attained finality. Full stop. Be that as it may, on remand, the Deputy Commissioner has passed the impugned order dated 36/2022, and the primary ground was that the present respondent, who was the present petitioner, who was the respondent before the Deputy Commissioner, had failed to produce any supporting documents. Full stop. In the considered opinion of this court, the exercise to be performed by the Deputy Commissioner qua the aspect of cancellation of the LPC of the respondent number 3 was only with regard to giving the said respondent number 3 an opportunity of hearing. Full stop. The said remand order was admittedly in terms of the order of this court dated 36/2022, in which there is a categorical finding regarding the affirmation of the KEBA decision. Full stop. The KEBA, in no uncertain terms, had arrived on the following conclusions. Page 45. I'll give you this. In view of such conclusion being affirmed by the High Court, there was no occasion for the Deputy Commissioner to reach at a conclusion that the conclusion as done by the impugned order. Full stop. The subsequent action of the petitioner approaching the civil court and withdrawing the same will not have any impact on the challenge presently instituted in this writ petition with regard to the impugned order dated 36/2022. Full stop. This court is of the opinion that in view of the affirmation of the findings of the KEBA dated 10/11/2015 by this court in its judgment and order dated 8/4/2022, comma, the impugned order cannot be sustained and accordingly the same is interfered with. Full stop. The writ petition accordingly stands allowed. No order is to cost.
Much obliged.
Rest, Madam will give dates. If there is any urgency, RD dates, otherwise we have to write, there's a reference.